Hello, hello, hello. This is Fox Revies here for our, oh gosh, what is it? Day 10. Wow, day 10 already. Day 10 update of the Kyle Rittenhouse trial. Well, today was the day. Today still is the day, actually. There is still closing statements, closing arguments still being made. The first two larger segments of the closing arguments have completed, and I am estimating another about an hour and a half from now, they should be done with the final closing statements, all of which I will explain here momentarily. And in fact, once I get through kind of my review of the first part of the day here, we're probably going to watch the rest of the closing statements near live. I'm going to go back and replay the parts that I haven't watched yet. Probably about half hour to 45 minutes behind real time. Maybe we'll watch it at a little bit of an accelerated pace, and we'll watch through to the end. But before we get to all that, why don't we go through what happened at the start of the day? So, if you've been following along with this series, man, you guys are troopers. I'm a trooper for doing this. But, man, we have made it to day 10. We have made it to the end of the trial. Today was the day everyone's been waiting for, which was the end of witness statements and the beginning of closing statements, at the end of which they will toss it off to the jury. And 12 random dorks from Kenosha will get to decide the fate of Kenosha hero, the Kenosha kid, Kyle Rittenhouse. I almost said Ryle Kittenhouse. That'd be a hell of a name. All right. So, what happened at the beginning of the day? So, at the start of the day, opened up with just the judge and the lawyers discussing amongst themselves what they were going to expect for the day. There was a lot of discussion about how was the judge going to be instructing the jury. So jury instruction is a process by which the judge will explain to the jury, this is how you interpret laws. This law means this. These are kind of the checklist of items that need to be met if you're going to be saying somebody's guilty of this. So, for instance, Kyle is being charged with first-degree reckless homicide. So there's 3 conditions that have to be met. There's specific conditions that have to be met to find Kyle guilty of first degree. And so the judge will explain to them, okay, here are the 3 ways that you test the situation to see if those conditions are met. If those conditions are met, you may then find Kyle guilty of first degree reckless homicide. However, if you do not, if one of those conditions is not met, then you cannot find Kyle guilty of first degree reckless homicide. Now, a whole bunch of yada 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 with the jury nullification. We're gonna just pretend that doesn't exist for right now. But what I just did is essentially what the judge did with the jury during the jury instruction. Now those instructions are rather important, right? Because you're telling the jury this is how you interpret the law, which, depending on how you interpret the law, depends on who wins, right? So there's a lot of back and forth about what specific instructions the judge is supposed to give the jury, and so there was some discussion about that. The defense, Kyle's defense lawyers asked to dismiss the gun charge due to lack of evidence. This was gone through on Friday, that the judge was considering it because the law in Wisconsin, basically, without going through the entire explanation again, it is legal in Wisconsin for 16 and 17-year-olds to possess and carry AR-15s. It just is. Now, the state wanted to they wanted to keep that open as a possibility because they said, well, what if Kyle's rifle was a short barrel AR? What if it was shorter than 16 inches? As many of you may know, if you have an AR-15 that is shorter than 16 inches, you now have a short barrel rifle, and unless you have a very specific, very expensive license, that is illegal. And so the state said, well, we understand that perhaps it's legal for Kyle to carry an AR, but what if that was an illegal AR? And the judge says, well, you guys have had the AR for 14 months. You had the ability to test to see if it was shorter than 16 inches with a ruler, and whether you did or did not do that, you've not presented any evidence. The burden of proof is on you guys. If the state has provided no evidence that the barrel length was too short, then we have to presume that it's the correct length. And given that the AR-15 was there in the room with them, and they had a yardstick and a measuring tape, it was a rather stupid argument. The state knows that the barrel length is not too short, so it was dumb of them to even bring it up. But given that the state has no evidence that the gun itself was a illegal build, and that Kyle, being 17 at the time, was under Wisconsin law allowed to carry, then the judge has now decided that he would dismiss the gun charge. So that was good. One of the things Kyle was charged with among the 6 charges was that he was charged with, I forget what the specific language was, but it essentially boiled down to either illegally possessing or illegally carrying a rifle or a dangerous weapon. That was the charge. That charge has now been dropped. So that actually does color a lot of what the jury is going to do. So that was new this morning. That's going to color a lot of how the jury is going to interpret the other laws, because typically it doesn't look as good in Kyle's favor if, let's say, it turned out that it was illegal for him to be carrying that rifle, right? So if Kyle's carrying an illegal rifle, whether or not he has the right to self-defense, being independent, it won't matter from a jury perspective, right? They should, even if Kyle was carrying it illegally, they should look at those as separate issues. But we all know how human nature works and juries and things of that nature. So this is good because it makes sure that Kyle doesn't unnecessarily get biased by the jury, who says, yeah, well, it's okay if he did self-defense, but like he was carrying an illegal rifle, so we're going to say that he doesn't have the right to self-defense or something like that. So that was good. So Kyle started off the day with having one of his charges just disappeared. That was great. The defense, Kyle's defense attorney, who had made notice last week that they intended to file for a motion to dismiss with mistrial, that they had intended to make a motion for a mistrial with prejudice. Last week they had declared their intent to do that. As of this morning, they have officially filed that. Just quick recap on a mistrial with prejudice is normally a mistrial by itself. The state would have the opportunity to retry Kyle, and we'd have to go through this entire trial again. However, if it's mistrial with prejudice, then the judge can just say, mistrial, all the charges are dismissed, and Kyle cannot be recharged with this. He's free to go. That would allow Kyle to get off of all the charges without having them be revisited upon him later, which would be a desirable outcome. The judge has reserved the right to make a decision on this motion later, which is what was expected. And so what could happen is if the jury comes back and finds Kyle guilty, the judge would have the opportunity to say that he is now accepting the motion for mistrial, and no matter what the verdict is, even if the verdict's already been rendered, the judge has the ability to just mistrial, and the verdict doesn't matter if it was guilty or innocent, whatever, it just goes away. Kyle's free to go. So there is some people considering that might be what the judge is doing. The judge also has the right for directed verdicts on several of the charges. So if, for instance, the jury finds Kyle guilty on first degree reckless homicide, that'd be the big one, and the judge says, well, I was there at the trial that you guys were at, the state did not provide sufficient evidence, the judge can just make a decision that he's going to reverse the verdict. That is a possibility that he has. So we don't know what's going to happen with that. The judge has made much effort to get this to jury, despite the ravings of detective or no lieutenant attorney or I don't know, whatever the hell Binger is, not lawyer Mr. Binger. Despite the attempts by Mr. Binger to get this trial thrown out by severely violating the constitutional rights of several witnesses, the judge has very much wanted this to go to the jury just to see what happens. And so he continues that by not deciding on the mistrial quite yet, though he will possibly do that after the jury comes back. So there was a lot of discussion between the lawyers and the judge about what the specific language in the jury instruction was going to be. After they finished that, the jury was invited back into the room, and the judge began instructing the jury. This was a very long process because he had approximately 31 pages of jury instruction to give, all of which was very complicated. I was doing work while I was listening, so I wasn't following super intently, though I did try for a little bit of it, and it was dense. It was dense. I do not know how the jury will be able to. I don't know. It'd be interesting to see how the jury interprets some of the stuff that was said, just because it was, an hour of legalese just dumped on them to analyze, I guess. Let's see here. The judge did, during the jury instruction, the judge got stuck on the instructions for lesser charges. So we talked about this on Friday. Friday, the state prosecutors basically just dumped this snow job of additional charges on Kyle. So the state had conceded that they were pretty sure a reasonable jury would not find Kyle guilty on any of the charges because they knew that their case sucked. And they actually said that. I'm not exaggerating. They actually said that they said that they did not think a reasonable jury would find Kyle guilty on the charges. And so they wanted to get something else to stick on Kyle. So they've got Kyle charged with the most severe counts of murder that you can have, which was stupid on their part to start off with that. They essentially charged Kyle with essentially premeditated, intentional hunting people down, which is just so clearly not what happened. But because they overcharged him, it's really hard to prove that Kyle had premeditation. In fact, it's impossible to prove that Kyle had premeditation on this. It's impossible to prove that Kyle went around hunting people. The state attempted to make this circuitous, argument that Kyle's TikTok bio of just trying to be famous, that somehow constituted motive, and that Kyle cleaning graffiti the day before, that was him just trying to create this false narrative so that he'd have cover when he went out to hunt people later that night. It's completely ridiculous. But if the state had just charged him with second or third degree reckless homicide, they might have gotten that to stick, but they tried to charge him with first. And so to make up for that, now at the end of the day, we're on the last few minutes here. I don't know sports. The last 5 minutes of a soccer match. You've got Binger saying, okay, well, we're going to add in, I think they added in almost 10 additional charges, and they're all lesser charges. They're all basically duplicates of the steep charges of first-degree homicide, and Binger just lumped in a bunch of lesser versions of that. So now we've got a bunch of counts of second-degree reckless homicide or second-degree reckless endangerment. And there's a few others that were, I think the one... I can't remember exactly what it was, but the one count of first-degree reckless homicide, that had 3 additional lesser charges attached to it. And so now the jury, instead of looking at 6 charges, which now it was 5 charges because the gun charge was dropped, now the jury has the option to charge Kyle with something like 12 to 15 different counts of stuff. It's ridiculous. Absolutely ridiculous. So why am I bringing this up? So if Kyle is guilty of first-degree reckless homicide, he can't then also be guilty of second degree. It's one or the other. If Kyle is guilty of second-degree reckless homicide, he then can't be guilty of first-degree reckless homicide. So if you pick him being guilty as one, then he can't be guilty of the lesser or the greater. It can only be one from the group. However, hold on a second. You guys should be super glad I muted that. That was an epic sneeze. All right. Either way, so first degree and second degree, he can't be guilty of both. He can be guilty of neither, and he can be guilty of one, but he can't be guilty of both. So there is instruction that if you find him guilty of first degree, then stop looking at the second degree, it's irrelevant. You can move on to the other charges. If you find him guilty of second degree reckless homicide, then stop. He's not guilty of first degree reckless homicide. It can't be both. However, because of the nature of the self-defense argument, if it is found, so it is understood that Kyle killed somebody, right? So this case is a little bit different than a regular murder trial because it has self-defense. Self-defense says you are allowed to kill somebody. That's essentially what self-defense boils down to when you grab the when you invoke the privilege of self-defense. That privilege allows you to break certain other laws. So if Kyle is not guilty of first-degree reckless homicide, then he's only not guilty of it because he has the privilege of self-defense. If he wasn't invoking self-defense, he would just automatically be guilty of first-degree. But because he's invoking self-defense, if he's not guilty of first-degree reckless homicide, it's only because he is invoking the privilege of self-defense. And so if he has invoked the privilege of self-defense and that's been found to be a good invocation, and that he's not guilty of first-degree reckless homicide because of the self-defense, then he also cannot be guilty of second-degree reckless homicide for the same reason. So there was a bunch of kerfuffle again. I've been using that word because it's well descriptive of what's been going on in this trial. Also, several other people in the courtroom used that word this week, or in the past week, so I stand by it. There was some kerfuffle because the reason why the second degree reckless homicide and the additional lesser charges were put in is because Binger knows that he can't get Kyle on first degree. So that's why he put in the other charges, was hoping that something would stick. But what I just described there is, even if there's additional lesser charges, if Kyle's not guilty of the biggest ones, then he literally can't be guilty of the other ones because of the privilege of self-defense would extend to the lesser ones as well. So that seems very obvious to me. It seems very obvious to Kyle's defense team, and it seemed very obvious to the judge. However, Binger doesn't like it, and he essentially gave his reason as to why he didn't like it as, kind of this whiny groveling of like, well, if Kyle can't be guilty of it, then he won't be guilty of anything. It's like, well, yeah, Mr. Binger, that's how it works when you don't have a real case to bring against somebody, is that they're not guilty of it. Surprise, surprise. In Binger's world, if somebody's not going to prison, if somebody that Mr. Binger doesn't like doesn't go to prison, then in his mind, the law's not working as intended. However, the law does have, rules and laws that are associated with it. It does have text and things that function in a certain way. And so the judge kind of left it ambiguous, which he actually described a little bit why. So in other states, what I just explained is made very clear in the text of the law. In Wisconsin, it's implied that self-defense privilege for the first degree would also extend to the second degree, which hopefully I'm not confusing everybody. But in Wisconsin, it's just implied that that's the case, and so you have to make your legal argument around it every time. Whereas in other states that have better written self-defense laws, it's written into the text of the self-defense statute that explicitly it covers first, second, and third. However, in Wisconsin, because they suck at writing laws apparently, too much cheese in their brains, they have this open interpretation. And so because of this open interpretation, the judge has to give less than ideal jury instructions. So the way that it should work is the jury should have been instructed that if they find him innocent on the first degree reckless homicide, they have to find him innocent on all the lesser charges. However, because of the way Wisconsin law is written, the judge was kind of forced to leave that instruction ambiguous. So now the jury has the potential of finding Kyle not guilty of first-degree reckless homicide because of self-defense, but also guilty of second-degree reckless homicide because self-defense didn't apply, which doesn't make sense, but Wisconsin. All right. So let's see here. Then they start. So there was a few other discussions about certain things, but basically, again, the judge went through 31 pages of jury instruction. It was very long, very boring, very complicated. Then we get into the fun part of today, which was closing statements, which was odd because at first, and now I'm noticing as we've gotten through the day, I'm noticing that my initial assumption here was wrong. But the way the judge made it sound was that the state would get the final word. The state would get to go first in closing arguments, and then they would have the chance to rebut the defense's closing arguments, but the defense wouldn't have the opportunity to rebut them. However, that appears to be wrong, although I'm not positive on that. So we might find that out together once I catch up to real time here and we start watching it. But I'll let that slide for right now. So Binger got to start the closing arguments. And he started off with some interesting words that, quote, there's been a lot of static in this case, which I thought was very interesting that he would start off with, conceding that his case was built on literally static images, like fuzz and snow and out of focus pixelation in images, and that his whole case is built on literal camera static. But I think he was trying to imply something else, but it didn't sound great. There is almost immediately an objection. I think it was the second or third sentence that Mr. Binger said the defense objected, and that was because Binger referenced Kyle breaking curfew, but the curfew charge was dropped. In fact, the judge in front of the jury said, and he didn't say this last time that the curfew was brought up when the curfew charge was dropped. The judge actually said that it's not been proven that the curfew was even legal. So the judge is actually alleging that the city instituted an illegal curfew, which I find hilarious. Let's see here. Then Mr. Binger says, quote, most reasonable people would have followed the curfew. Again, talking about curfew after he was told not to, per typical Mr. Binger. And I think that's kind of interesting because, Mr. Binger's clients, more than half of which are dead, they were not, were they not reasonable people, apparently, because they were out past curfew. And I'd say that's actually a pretty good argument for the defense that, and I'd say it's probably pretty accurate too, is that Kyle was dealing with a bunch of unreasonable people that day. And had they had some reason, perhaps Kyle wouldn't have had to shoot them. Let's see here. Mr. Binger says, I just basically took a bunch of excerpts from Binger here, but he said, quote, the killings had nothing to do with protecting businesses, which I thought was pretty interesting that he would concede that as well. I think he was attempting to make another point, but regardless, he said this in context and was essentially trying to show that, well, Kyle said that he was there to protect businesses, but he really wasn't, because when he killed Rosenbaum, well, he wasn't at one of the businesses, which actually isn't true because he was at one of the car sources. So not only was Mr. Binger making an interesting point, but also it was wrong. It was actually just factually wrong that when Kyle killed somebody the first time that it wasn't in front of a car source, but it was. But this kind of undermines Binger's entire argument that Kyle was killing people to protect property. He just conceded that the killing had nothing to do with protecting businesses. So what is it, Mr. Binger? Is Kyle killing people to protect a building, or is he killing people for some other reason? I think it's been the defense's argument the entire time that there was some other reason, and that reason was to defend his own life. And I guess Binger agrees. It seems Binger was very swayed by the defense's arguments, apparently. Let's see here. Then Binger tries to remind the jury that during his opening arguments, he said, I asked each of you, is life more valuable than property? And you all raised your hands to say yes. And, I think that's funny because given his just immediately previous statement that, what Kyle did had nothing to do with protecting businesses, then the whole property argument's kind of irrelevant. You already conceded that it had nothing to do with protecting property. So why are you talking about property again? Because Binger wants to have this, at some points in the argument when it's convenient, Kyle was using his gun to protect property. At some points when the argument is convenient, Kyle was using his gun to go on a manhunt. And then at some points when it's convenient for Mr. Binger, it is, Kyle is, I don't know what, but playing COD or something, playing COD IRL. Let's see here. Mr. Binger says that, quote, all life is sacred, which I don't know. Rosenbaum, brutally, anally raped a 5-year-old and a 7-year-old and a 10-year-old and an 11-year-old and a 12-year-old. I'd say his life's probably not very sacred. Just saying. Let's see here. Mr. Binger said, quote, we can all agree that we shouldn't have 17-year-olds running around with AR-15s. I don't know. I don't know if that's a universal agreement point. But you see how Binger's characterizing this. That, it's if the argument is that we shouldn't have 17-year-olds running around with AR-15s, then, well, maybe why do we need 18-year-olds running around with AR-15s? Why do we need 20-year-olds running around with AR-15s? Why do we need 30-year-olds? Why do we need 60, 70, 80-year-olds. As soon as you start, Wisconsin law has stated, maybe not quite in the same the same loaded words that Mr. Binger has said it in, but Wisconsin law has said it is okay for 17-year-olds to run around with AR-15s. That is why that gun charge was dropped. So maybe you shouldn't have them. I don't know. That's up for the people of Wisconsin to decide. So far, as the law says, the people of Wisconsin have decided that they do want 17-year-olds running around with AR-15s. Mr. Binger can lobby to change the law if he would like, but he does not get to just rewrite it in the courtroom. The law is that you are allowed to do that. Whether or not Mr. Binger wants that to happen or thinks it's appropriate is irrelevant. It is what is the law. Court is not about what you think is appropriate. It's not about your wishes, your hopes, your dreams. Court is about what is the law. And what the law says is that 17-year-olds are definitely allowed to run around with AR-15s. Perhaps Mr. Binger, after this case, would like to lobby the Wisconsin State Congress to change that law, and he's certainly welcome to do that. However, in the courtroom, he is not allowed to suggest that is not the law, or to try to coerce the jury into making a decision about that law based off their feels about what the law should be. In fact, what Mr. Binger is suggesting the jury do is essentially jury nullification. They would be nullifying the exception in the law. Normally nullification's thought of as this good libertarian anarcho-capitalist type thing where you're getting rid of the laws of the man. But in this case, Mr. Binger would be asking the jury to nullify a law which protects the Second Amendment rights of 17-year-olds. So, not all jury nullification is all sunshine and rainbows there. Mr. Binger said at one point that the defense wanted to, quote, tailor the facts and see what you want to see out of it. Or that you didn't want them to see what the defense wanted to see out of it, which I thought was a pretty interesting way of putting it, that Binger was accusing the defense of tailoring the facts when Binger is literally, using an X-Acto knife to carve out 13 pixels on this drone footage from 180 feet away, and then zooming in on 30 pixels across and turning it into 3,000 pixels across and saying this blob proves Kyle's a bad guy. That's, yeah, you want to talk about tailoring facts, Mr. Binger. That's pretty rich. At this point, I just wrote down that there was a lot of lies that weren't really worth going into, which is probably accurate. Binger's first segment went for 2 hours, 10-ish minutes. There was actually some debate as to how long it went, but it was about 2 hours, 10 minutes. And basically, it was all of the stuff that you've seen on Twitter. Essentially, Mr. Binger allowed Twitter from the last 14 months to write his closing arguments. It was a lot of the exact same tropes that we've seen from all the left-wing smear merchants the last 14 months about Kyle. All of that stuff that was debunked during the trial And somehow it all just comes right back up as Mr. Binger's like closing arguments, like the de facto, this is what really happened. This is how we know Kyle's a bad guy. This is why he should have let a 5-time pedophile rapist touch him one more time. That's why I just wrote down just a lot of lies not worth going into, because to go back through everything Binger said was just to re-debunk all of the things that we've seen and debunked on Twitter for the last 14 months. And I will say, as I said at the opening statement on day one, Mr. Binger's a good speaker. He is a very good speaker. He's a lot of lies. He's very slimy, but he is a good speaker. He has a good speaking voice. He has a good speaking cadence. He has a good tone. He knows how to speak dramatically, though he did try to overdo it at one point and yell at Kyle, but not nearly as bad as how the defense started off, which we'll get into. And I think that from a juror's perspective, if you're not paying attention, you just hear Mr. Binger say sweet nothings into your ear and think, oh wow, he must be telling the truth, because he sounds very nice while saying it. And I mean, isn't that kind of the cliche lawyer? Is it they're slimy, greasy slime balls, and they're smooth talkers, silver tongues, causing trouble, and trying to talk you out of your money, try to lie to you, try to get you to believe things, or confidence men, that sort of stuff. And that's Mr. Binger in spades. Absolutely. Like I said, doesn't mean I like the guy, but he's a good speaker. Alrighty. So Mr. Binger suggests that, quote, Kyle doesn't get a pass for being fast. This is in response to Kyle shooting off 4 rounds in 0.76 seconds, which I have tried to shoot off even 2 rounds that fast out of an AR, and that is pretty quick. That is a cranking trigger finger right there. So it is Binger's contention, it's the state's contention, that Kyle, after shooting Rosenbaum once, he could have just stopped shooting Rosenbaum because Rosenbaum was no longer a threat. For Kyle to have recognized that Rosenbaum was no longer a threat first, Kyle would have had to been able to see and react in slow motion, as we saw in the video. Also, Kyle would have had to have x-ray vision to see that his first shot shattered Rosenbaum's pelvis, making Rosenbaum likely immobile. But the state says, well, after the first shot, which disabled Rosenbaum, there's no way for Kyle to know that. He chose deliberately to shoot off 4 more rounds deliberately. And again, when the defense brought this up, when you slow down the video by a quarter or an eighth, and then you see Kyle making these deliberate you see that deliberateness in the video when you slow it down. When you speed it back up, it's real quick. It's real quick. You can't even count to 8, or you can't even count to 4 in that many seconds in your head. Kyle, his testimony was that he shot until the threat was eliminated. That is absolutely correct. That's what he did. There is nothing in self-defense law which states that the number of bullets that you shoot into somebody is, problematic, or that is indicative of some kind of breaking of your ability to be defending yourself. That it's 3-shot minimum or something, or 3-shot max kind of a thing. Like, no, there's nothing in self-defense law that says that. There is no logical reason why 4 shots within 0.76 seconds, why that's too many, or that shows that Kyle had some kind of deliberate malice after the first round. No, it just shows that Kyle thought he wanted to do a quad tap on the pedophile chasing him, and that's what it took to get Rosenbaum to stop coming after him. So maybe if Rosenbaum didn't want to appear as he was still going after Kyle after the first shot, maybe Mr. Rosenbaum shouldn't have been lunging at Kyle, and then maybe his inertia wouldn't have continued to carry him towards Kyle. So I don't know. I don't think that's going to play well with the jury. I think, in fact, kind of skipping ahead here, the defense did this very nice presentation in front of the jury box, which the cameras did a very good job of not catching the jury in. But the defense took out a tape measure, measured off 4 feet, which is the alleged distance that the state thinks Rosenbaum was. We know from a lot of different evidence that Rosenbaum was much closer, or where various parts of Rosenbaum's body, like his arms reaching, were much closer than 4 feet. But it is estimated by the evidence that Rosenbaum's torso was something like 4 feet away from the muzzle of Kyle's rifle. However, 4 feet leaning over, reaching your hand out, you can make up that distance real quick with your hand reaching out. Your hand reaching out is going to end up being about 4 feet away from your torso. So it is perfectly anatomically possible to be reaching out, touching the tip of Kyle's rifle while your torso is 4 feet away from it. And I mean, Rosenbaum loves grabbing them underage tips for sure. All right, so the defense did this very nice presentation where he walked up to the jury box, measured out 4 feet, got his feet planted there, and then reached towards them and said, "Now imagine if I'm running full speed at you, how quickly I can make up this gap." Because it was the state's contention that Kyle shot Rosenbaum when he was super far away from him, which is totally ridiculous. It's just completely not in the video, not in the evidence. Nothing's ever even said that. I guess it's the state's opinion that 4 feet is a very long way away. That I don't think that's going to play. I don't think that's going to play at all. Let's see here. Then the defense goes into their foggy image, which actually I have that from last time. They were showing this image that is in the exhibit meme, and then also this video, which is up in the Binger and lunchbox, showing the judge there. Binger shows that image and then reenacts it with his hands empty. We'll see later on that Binger actually does go on to inappropriately pick up a rifle. The way Binger uses his body to demonstrate what he wants the jury to see in the image, Binger reenacts holding the rifle right-handed, even though it's Binger's contention that Kyle was holding his rifle left-handed in the image. Now, we know that Kyle wasn't holding his rifle at all. However, the only way that you could possibly imagine Kyle holding his rifle in that smear would only work if he was holding it left-handed. But Binger, to show the jury this, shows the jury a right-handed stance, intentionally trying to confuse them. Well, I guess we'll see if it works or not. Let's see here. Then Binger plays the Rosenbaum shooting from various angles over and over and over again, and all the while explaining that Rosenbaum was way too far away to ever touch Kyle's rifle, even though you can clearly see in the video that he's replaying that Rosenbaum's hand is like right next to the rifle, which is what the testimony of the state's doctor was. I don't know. I guess you've heard this before, where there's kind of the one screen, two movies thing, where you've got the right and the left. Now we'll see the same event and we'll have agreement about what happened, but we'll have wildly different interpretations about what that means. And so you've got this objective video clip of Rosenbaum leaping at Kyle with his hand on Kyle's rifle right before Kyle shoots. You've got this objective video, and there's no disagreement about what it shows. It's just the state wants to characterize the distance as far away, when I guess I consider myself a reasonable person. I don't think that distance is a right-wing philosophy or concept, but apparently it is now. I would say a reasonable person would consider that to be a close distance, but Binger can show the jury a video and then say that the video shows them something else. If that's what he thinks is going to be an effective argument, then, I guess all the more power to him. Let's see here. Again, goes through the demonstration that, Binger holding the rifle right-handed and explaining that Kyle was holding it left-handed. He again keeps reiterating that Rosenbaum was really far away when Kyle shot him, which I don't think I need to replay that video. I think it's pretty obvious that Rosenbaum was like right on top of him, as per all of the testimony, all the video, etc., etc. Then Binger, hold on a second. Then Binger gives us this really weird explanation that it was Kyle's choice to run into a corner, and that's why Rosenbaum gets closer to Kyle. It's not that Rosenbaum was chasing Kyle. It's that Kyle chose to run himself into a corner and then to stop running. I said this last week, but I'll say it again. Had Mr. Binger been, I guess, representing Rosenbaum in the child rape cases, would Binger have, I guess, chided the children as that it was their fault Rosenbaum brutally raped them because they stopped running? Is it the 5-year-old's fault that Rosenbaum anally penetrated him over and over and over again and left him severely disabled afterwards? Is it the 5-year-old's fault because he stopped running? It goes to the same thing with the 6-year-old, the 8-year-old, the 11-year-old, the 13-year-old, et cetera, et cetera, et cetera. But apparently now it is the victim's fault that if you stop running, or you've run yourself into a corner or a maze or something like that, well, it's your fault, not the person chasing you. It's your fault for stopping running. How could you? Let's see here. Let's see here. The state says, or Binger says that there's, quote, no evidence that Rosenbaum was reaching for the gun, even though the state said while Kyle was on the stand that Rosenbaum was reaching for the rifle to push it out of the way so that he wouldn't get shot. So which is it, Binger? Was Rosenbaum reaching for the rifle to push it out of the way, or was he not reaching for the rifle at all? So the only evidence that Rosenbaum was reaching for the gun is 4 or 5 different video angles and then 2 or 3 different testimonies, 2 of which were state witnesses testifying to the effect. So I mean, I guess if that's what qualifies as no evidence, I guess maybe. Then Binger says, quote, to the extent that Rosenbaum's hand ever got close, it was completely inadvertent and not intentional at all. I'll read that again. Binger said, quote, to the extent that Rosenbaum's hand ever got close, it was completely inadvertent and not at all intentional. I guess you just accidentally chase somebody across a parking lot and put your hand on their rifle barrel. It was probably Kyle's fault for turning around. If Kyle had just kept running, Mr. Rosenbaum would have never been able to get his hands on him. Probably Kyle was begging for it. That's probably what Binger was getting at here, is that Kyle just wanted Rosenbaum to molest him, and that's why Kyle stopped running. Because, if Kyle didn't want to get molested, he probably would have just kept running, right? Let's see here. Then Binger says, let's carve out the Zeminskis. So the Zeminskis are these 2 people who are seen with Rosenbaum essentially at all times that night in all the video. The Zeminskis are, Mr. Zeminski is the one that shot off the pistol prior to Kyle shooting off 4 into Rosenbaum. It's kind of believed that initial pistol shot is that initial pistol shot into the air is what kind of kicked off the events. Let's see here. So the earlier explanation from Binger of Kyle holding a rifle at somebody is possibly that Kyle is pointing a rifle at the Zeminskis. That is what the Binger said. That's what the state's position is that Kyle was pointing a rifle in the direction of the Zeminskis, and that's what set off Rosenbaum. Now, mind you, that doesn't make any sense. Even if it's true, Kyle pointing a rifle at the Zeminskis does not in any way give Rosenbaum permission to chase Kyle down. And it would still be, because basically what the state wants to say is this was provocation. Kyle provoked Rosenbaum by pointing a rifle in the general direction of the Zeminskis. If that's true, if it is provocation, then Kyle can't claim self-defense. However, it's going to be pretty hard to try to expand provocation of pointing a rifle at somebody else that's not Rosenbaum and say that that's what set off Rosenbaum and that provoked Rosenbaum. It's going to be pretty hard to prove that. I guess we'll see if that's a compelling argument to the jury or not. I don't think it is for me, but I'm not a juror. So, again, after telling the jury that Kyle can't claim self-defense because he provoked Rosenbaum by pointing a rifle at the Zeminskis, none of which is true, then Binger says, let's cut out the Zeminskis. The defense is going to talk a lot about the Zeminskis and their possible relationship with Rosenbaum, and I'm here to tell you it's not relevant. It's not relevant at all. Let's carve the Zeminskis out of this case. And I just think it's insane that he would talk about that like immediately after talking about Kyle pointing a rifle at the Zeminskis. Binger wants to. This is again Binger. When it's convenient, Zeminskis are part of the case. When it's inconvenient, the Zeminskis are not a part of the case. Binger wants to have his cake. He wants to eat it too, and he wants the cake to also be the thing that provoked Rosenbaum. Then Binger goes into what I am sure. Oh God, this is going to be a clip that probably goes around for a little while. There's been some discussion, and Crowder has said it rather elegantly, that this is not Kyle on trial right now. This is your right to self-defense on trial right now, and it really, really is. The arguments the state are making against self-defense in this case are terrifying. These rulings just cannot be allowed to stand if Kyle's found guilty. But we'll get into that in a second. The state says, Mr. Binger says, quote, "This is a fist fight." So Binger goes through kind of this winding story that he's conceding Rosenbaum did intend to beat Kyle up. That Rosenbaum did intend to use his fists to beat Kyle up. But Kyle doesn't, just because Rosenbaum wants to have a fist fight with Kyle, that doesn't mean, quote, Kyle gets to bring a gun to a fist fight. It is the state's position that you are not allowed to bring a gun to a fist fight with somebody who's chasing you down and intends to beat you down. That cannot be. That cannot be. I don't even know if I have to explain why that cannot be, but that cannot be. Also, while talking about this, Binger finds it appropriate to post a meme of a meme from the movie Roadhouse, which I haven't seen myself, but I believe it is a movie which prominently features burly men beating each other up with their fists. And Binger is posting a meme on his PowerPoint that he's showing to the jury from Roadhouse saying, you can't bring a gun to a fist fight. Then Binger says, quote, "You lose the right to self-defense when you bring a gun." Binger says, quote, "You lose the right to self-defense when you bring a gun," end quote. What? I never like to just be indignant about things I'm commentating on, right? Like you guys tune in to hear my commentary on stuff. You don't tune in just to hear me go, "Man, can you believe that?" and then not explain like the philosophy or the reasoning or anything like that. Just being indignant about something and like having that be evidence why it's bad. Given that this situation, this covering the trial here is more of a fact-finding reporter mission here, because I'm observing primary sources and then bringing you guys bringing to you to report on the interesting tidbits here. I am adding my commentary here, but for me to explain to you the philosophy of what is wrong with that statement, what is wrong with the statement that you lose the right to self-defense when you bring a gun. I I think I could probably, it would take me 5 hours to appropriately explain that, because you're getting at bedrock foundational conservative principles here. Not even just conservative principles, bedrock American principles, because this is an issue that has its bedrock in the Constitution. This is actually American fabric. As much as people like Mr. Binger and the Democrats and Joe Biden and everybody else, as much as they abhor the Constitution, as much as they abhor America, it doesn't change the fact that what they are talking about right now is bedrock, not any law, not any other political theory or particular state's issue. No. This is a very specific bedrock amendment in the Constitution given to us by our founding fathers at the very beginning of everything. This is not something that the state should be saying. In saying that, quote, you lose the right to self-defense when you bring a gun, I believe that statement represents Mr. Binger violating the Constitution. I think that it's actually, as a representative of the state, Binger's not there in his own personal capacity. He doesn't have First Amendment rights when he's speaking on behalf of the state, as he is now. I think it's actually illegal for him to speak like that in a courtroom while he is speaking on behalf of the entity of Wisconsin. Wisconsin as a conceptual legal entity, the state. Mr. Binger is a representative of that state, and I think it's actually unconstitutional, like to the point of being illegal for Binger to talk like that. That is a strict violation of the Second Amendment, and the state, the Constitution is there to restrain the state. It's there to restrain the government from doing things to you. The government isn't itself a person. It has representatives that act on its behalf. Binger is one such person. Binger is one of the people acting on behalf of the state. The Constitution is there to restrain people like Binger. It's there to restrain people like Binger from suggesting that you don't have the right to keep and bear arms. Binger is violating the Constitution here. What he said is illegal. It is illegal for him to say that. If he, outside the courtroom as a private citizen, wants to carry a sign around and say, you don't have a right to self-defense, you don't have a right to keep and bear arms, that's perfectly fantastic. That is protected First Amendment speech. But if Mr. Binger, in his capacity as a legal representative of the entity that is Wisconsin, he does not have the right to say that. It is illegal for him to say something like that. And while we live in a country where it is legal for the state to say unconstitutional things in their attempts to prosecute you, that is a problem. That is a problem. I think that we need to have some kind of reform that would restrict what the state is allowed to say when prosecuting you. The state cannot be allowed to make anti-constitutional arguments in its attempts to prosecute you. That's ridiculous. All right. Let's see here. Then Binger says that the defense is going to tell you Rosenbaum threatened to kill Kyle, the defendant, which never happened. Which is funny because basically Binger's just saying ignore 5 of the state's witnesses, because 5 of the state's witnesses testified that they saw Rosenbaum at various points in the night say in various colorful ways that he would like to kill Kyle in various horrific fashions. So I guess it's Rosenbaum's position that his own witnesses, that he himself, the state called, that the jury should just ignore them. The jury shouldn't trust the people that the state called as witnesses. I mean, interesting tactic. Probably not the one I would have chosen if I was prosecuting this case. But I'm not a lawyer, so maybe I don't know what I'm talking about here. At this point in my note, I wrote the number 2. I don't know what that one's about. Then I wrote lies, which I'm guessing was probably just more lies. Then we move on to Binger discusses how the crowd has a right to self-defense. In speaking that, the defense wants to say that Kyle's got the right to self-defense, but you're not considering the crowd. The crowd has a right to self-defense. First off, we do not do the mob is not a legal entity in it's not a recognized legal entity in any jurisdiction in America that I know of, and also the crowd isn't on trial. If Mr. Binger would like to bring the crowd in as a defendant, then that is, I guess, supposedly open to him. I don't think there's anything stopping him from doing that other than it's impossible. But I don't know. Binger goes into this whole thing that he thinks that he's a defense lawyer for the crowd and that the crowd has this right to defend themselves by hunting Kyle down and chasing him down the street. Then Mr. Binger goes back into the TikTok motive where Kyle Rittenhouse's TikTok, 4 doors, more whores. I'd say give him a follow. Who has the bio, bruh, I'm just trying to be famous. Binger has brought up this bio over and over and over again. My Twitter bio used to say something about me being a fox. I hope that doesn't come into a legal defense in a court of law at some point. I mean, Fox Trevisi, he did this because he was trying to be a fox. You can see it right there. It's on his Twitter profile. If everybody was legally beholden to their Twitter profile or their TikTok bio, man, I'd like to see. I'd like to see Mr. Binger's his eHarmony account there. Let's see if there's any lies in there, any motive in there. So again, Kyle's bio and his TikTok, I'm just trying to be famous. Binger has brought this up 3 times now and is bringing it up in his closing argument that it is the state's argument that, brah, I'm just trying to be famous. Having that in your bio is motive for murder. That is motive for double homicide, attempted quadruple homicide. That Kyle was, in order to become famous, brah, attempted to hunt down and kill 4 people. I don't know how this is going to play. I don't know how. I guess it would depend on the age of the jurors. I have to imagine by this point, people understand bios, even boomers, even old people, because even old people are on Facebook. I would have to guess that is not going to be very strong. It might be for one of them, but I'm guessing that all 12 of them falling for that's probably going to be pretty much nil. And I can imagine conversation in the jury room is it just takes one person under 35 to say, dude, guys, bros, boomers, like this is not, it's just a TikTok bio. Like, don't put more effort into it than it needs to have. Like, I guess we should see, did Kyle having 4-door truck, did that get him more whores? Because we're alleging that the bio was motive, but what about the username? Is it true, Mr. Rittenhouse? Is it in fact true that you did get more whores after buying a truck with 4 doors? To which the answer is probably yes. But this TikTok bio as motive, if that's the best they got, I don't find it very convincing. I am concerned that a tech illiterate jury might be swayed, but I just find it hard to believe that a full jury would be that tech illiterate that none of them would understand like memery or I guess sarcasm, innuendo, etc. I don't like. That's even a pretty light bio for somebody who's got the 4 doors, more whores handle. I would say just trying to be famous is a pretty easygoing bio. Other than just saying, oh, Kyle's a misogynist, which I think is the worst way to take that. I just don't see how that's a compelling motive for murder. But it has been unfortunately shown that juries do more often than we'd like they will make decisions not based off the evidence, but whether or not they like the person or not. I think Kyle's got plenty of other character attributes that are check marks, and that this one red X here of possibly having a quote-unquote misogynistic, I don't think it is, but just that's what people say, misogynistic handle and a rather benign TikTok bio. I just don't think that's gonna. I don't think that's gonna fly. I don't think that's gonna have any weight with the jury, but it might. All right. Then Binger starts getting close to the end of his initial closing arguments and calls Kyle and his group rats, which was, you know that it's going well when as a lawyer when you have to resort to calling your opponent a rat. Then he belittles Kyle, saying that he was essentially a sniveling, whiny little 17-year-old. Then he calls Kyle pathetic. Okay. If schoolyard name calling and your TikTok bio is motive, if that's you're really scraping the bottom of the barrel there, Mr. Binger. Let's see here. Then to kind of wrap it all up, Binger says that essentially Kyle can't claim self-defense because Kyle provoked the situation, not by allegedly pointing his rifle at somebody, but by merely bringing a rifle at all. Kyle provoked the situation. This is what I'm talking about. This case, if Kyle's found guilty, it absolutely has to be immediately overturned with prejudice, because it cannot stand that merely having a gun is itself provocation to the extent that you have to just die or be beaten up, and that you're not allowed to defend yourself. That as soon as you bring a constitutionally protected implement to defend yourself, that all of a sudden you aren't allowed to defend yourself. That is a paradox, but also it just cannot stand. That cannot be allowed to stand. And the fact that that would result in such a paradox, I would hope that a jury would notice that and say, well, hold on a second. If he can't do it then when could he do it? I would hope that some of them carry. I know that the initial jury pool. Now we don't know how many people ended up on the jury with this, but we do know some of the initial jury pool had said, several of them had said that they had actually applied for their CCW and began concealed carrying and were first-time gun buyers. Several of them, as a direct result of what happened in Kenosha and what happened in the summer of 2020, that in the past year since what happened with Kyle happened, that many members of the jury had become new gun owners. So hopefully some of them made it onto the main jury, but it cannot be that merely bringing a gun, that merely having a gun on you is itself provocation, and that you cannot claim self-defense. That's ridiculous. What you see up on the screen here is Binger holding Kyle's rifle like an idiot. He's also pointing it at not quite the jury, but the people at the edge of the spectators area. Binger should be happy that's unloaded, because one, he's got his finger on the trigger, which he shouldn't have his finger on the trigger. I don't care if it's unloaded or not. That's not gun safety, which clearly Binger knows nothing about. But also, so Binger has his finger on the trigger, which is wrong. He should have it straight out. Also, if Binger were to actually fire that rifle at that moment, his dainty grip on the barrel and his barely getting that thing up against his shoulder, it is my guess, also the way that he's got his face on there, it is my guess that if Binger actually fired that, I don't think it would rocket off the back of his shoulder, though it is slightly possible. What's more likely is because he doesn't have it well braced against his shoulder, and he has such a faggy grip on the front of it. I'm allowed to say that. if he were to fire it, it's much more likely that the rifle would buck upwards. Also, I don't see, it doesn't have a good compensator on it. So it would buck upwards and probably give him a pretty good bruise on his cheek. Might cut his cheek, might give him a black eye. But if Binger were to fire that, he would get a face full of First Amendment, or Second Amendment, rather. I would certainly love to see that. So that was Binger's opening to his closing statement. Then we had the defense attorney, Mr. Richards. And basically the way it went was Binger talked for about 2 hours and 10 minutes. Richard talked for about 1 hour and 45 minutes. And then right when I started, Lunchbox, whoever Binger's partner is, started doing a rebuttal, which he would have had about 20 minutes to do rebuttal. And then Kyle's defense attorney, probably Richards or whoever again, would then go back to have a rebuttal. So after I get through explaining what Richards did for his first spot, we're actually going to watch through the rest of that because I haven't seen it yet and I want to see it. So I'll just watch it with you guys. Okay, so Binger sits down. Thank God. Richards gets up. Richards is the larger defense lawyer, not Mr. Lex Luthor. Richards was not as smooth. We'll get into that. So he starts right off the bat by debunking Binger's video. So Binger, during his closing, had showed a video where it was kind of weird because Binger says, the defense told you that Rosenbaum said he was going to kill Kyle. Here's a random video. I didn't see Rosenbaum say he was going to kill Kyle. Did you? Rosenbaum's not even in this video, which is, I don't think that's really compelling because there was like hundreds of videos from that night, and I mean, most of the videos Rosenbaum didn't say that he was going to kill Kyle. It was the ones where he did say it that was probably at issue. So I don't know. It was a little bit weird for. I don't know. It didn't really make sense to me why you would just pick out a random video and why that would be compelling. That like, oh well, you don't see it in this random video I picked out, so it's not there. I don't think that's proof that it never happened. Either way, Binger said conclusively in his closing statement that this video did not even show Rosenbaum in the video. And then the first thing Richards does when he gets up is say, hey, this video that Binger was just showing you that he said very specifically he didn't see Rosenbaum in. Here's Rosenbaum on this freeze frame we just took here. So I thought that was a pretty funny start. Then let's see here. From there, Richards had some very strong language. Richards we'll get into that in a second. But he started off by saying, Binger is going to use this image to lie to your face. That was in reference to the smeary drone cam blob. And Richards was very clear. He's like, that Binger is going to use this image to lie to your face. Which was very obvious from, again, Binger showing videos to the jury and explaining things to the jury that were not happening in the video, which was weird. And Richards said, quote, my client had to deal with him in reference to Rosenbaum. I initially thought, oops, that's not probably the best way to phrase it, that Kyle was dealing with people. However, it would seem that throughout Richard's closing arguments that his style was essentially to lean into the fact that Kyle shot and killed these people. At one point, Richard says that he's glad Kyle shot Rosenbaum because otherwise Kyle would be dead. And I at first I didn't think it was a good strategy, but now I do. I think it was a fine strategy to lean into it. Not just that Kyle was not wrong, but that actively Kyle was right. It's not enough to be anti Kyle did something wrong. You have to be actively pro Kyle did something right. And I agree with that. I'm actively pro Kyle did something right. I think Kyle acted perfectly in most moments that night. Certainly in the 2 minutes and 50 seconds between the first shot at Rosenbaum and the Kyle turning himself in with the police, which was a very quick amount of time, way quicker than a lot of people thought before the trial started. I think Kyle acted nearly perfectly in all those situations. So I do agree with Richards that you have to be actively Kyle did something right. Not just that he didn't do anything wrong, but Kyle did right stuff that night. Now, this may or may not play well with the jury, right? So if you have a jury who's predisposed to be against Kyle and you start saying, not just that we're conceding Kyle did something wrong, but it wasn't that wrong, that might get the jury on your side. But if the jury is already predisposed against you and then you really lean into what Kyle did and say Kyle did the right thing that night, you're going to risk polarizing the jury. So I don't know if this is going to be an effective strategy. I understand the strategy. I was kind of surprised to see it. And actually, in a way, it's morally right to argue it like this. But at this moment, I'm more worried about getting the charges dismissed, getting Kyle found not guilty, rather than making the correct philosophical or moral framing of the argument. At this point, whatever it takes to get Kyle's charges dismissed is, I think, the correct way of going about doing it. While I might see it as kind of necessary to the broader national conversation about Second Amendment and right to self-defense, that it's better for the national conversation if this is fought in the manner of you have the absolute right to self-defense and it's a good thing when you defend yourself. That's great philosophically. Whether or not that's great for Kyle might be a different thing, though. So, again, two ways of looking at it. Great philosophically, I don't know if it's going to be great for Kyle. I'd much rather have whatever it takes to be good for Kyle. If, some people are saying, well, I don't really want the judge to declare a mistrial with prejudice and just drop the charges because, then the left and the media, they're going to just say, oh, it was rigged. And I'm saying that even if Kyle goes through the jury process and gets all the charges dropped with the jury doing it, the left is still going to say that. The left will always say that. It doesn't matter how you do it, they're going to say that. So at this point, given that the left, there's no way to convince them otherwise, given that the left is so dead set on sending Kyle to prison forever, and that they're going to riot with or without that, I really don't see a point in playing the game. If nothing will satisfy them, if they won't accept the innocence through the proper legal proceedings, then I say to hell with the legal proceedings. If Kyle gets off with the jury, great. If it takes declaring a mistrial with prejudice, great. If it requires the judge to do directed verdicts, great. I don't care what it takes. Kyle needs to be found not guilty on everything and go free after this. Kyle needs to be a free man next week, or something went wrong, and I don't care what it takes to get there. I don't care if it was a little bit weird or if it wasn't the proper jury process, because it doesn't matter. The result from the left will be the exact same. They will be upset about it. It doesn't matter. And even if Kyle goes to jail, do you think the left is going to stop rioting? Do you think they're going to stop coming after your kids? Do they think they're going to stop coming after you at work? Do you think that they're going to stop doing all of the stuff that they do? No. So what does it matter? What does it matter? What Kyle's doing is so obviously correct. What he did was so obviously correct. I don't want to use him. It's not fair to use him as this chess piece in the culture war that, well, if we sacrifice Kyle's pawn or put him in a risky position and maybe he becomes a queen at the end of the board there, if we do it in just the right way, well, that makes the rest of the board better. It makes it more playable. It makes it, it easier to win in a different way. No. That's not fair to Kyle. He's not supposed to be used like that. He should be let free because what he did was individually correct. We're not going to do this kind of leftist collectivist thing where, well, Kyle, I understand that you've individually done something correct and that if we defended you in an individualized way, you'd probably get all the charges dismissed. But, it's just more convenient for the broader narrative if we just, defend you in not as effective a way, but something that's more philosophically and politically correct. If we defended you like that, maybe you'll still go to jail, but for the broader narrative, you'll help out the conservative movement. No. I don't care what it takes. Kyle needs to be set free next week. Doesn't matter if the left is happy about it, because the left's never going to be happy about it. Doesn't matter whether or not it helps the broader narrative on the Second Amendment. What helps the broader narrative on the Second Amendment is that Kyle goes free. I don't see any other. There's no other philosophical argument around that can be made. So if we'll see if back to Richards, we'll see if that gamble of really leaning into self-defense, if that's successful. Like I said, I like the argument. I think it's a good way I think it's appropriate to argue that on the national stage. However, is that the best argument for Kyle in this particular situation? I don't know. I really don't know, and I hope it is. I really do hope it is. All right. Then Richards quotes Binger from Binger's opening statement 2 weeks ago, where Binger said something about Kyle having an AR-14. I'm not sure, actually, if Binger said AR-14 or if Richards misspoke. I think it might have been Binger that misspoke and Richards was making fun of him, because Richards would go on to say AR-15 correctly many times. So I think that this was... No, I don't remember Binger saying AR-14. I feel like maybe I can force myself to like have a false memory of it, but I don't specifically remember it. Let me know in chat if that's a thing that we remember. Hold on a second. Okay. Yeah, let me know if that's a thing that everybody else remembers, if Binger actually said AR-14. I don't seem to remember that. Obviously, that'd be something that'd be in the video of the testimony if he did say it, but I don't know if that's accurate or not, though I want it to be true, so it's true for now. So while Richards was speaking, I certainly noticed for the first hour, now he did get better, but the first hour was rough. It was real rough. Give me a second here. Let's see here. Hey, Ava Nova, how you doing? Let's see here. So, as I said earlier, Binger is very well spoken. He has a very good speaking voice. He has a very kind of smarmy confidence man way of speaking. We're like, wow, he is a good speaker. I know a lot of people won't admit that just because he's such a sleazeball. I'm not afraid to say that he's a good speaker because it's important, because the jury will think that he's a good speaker, and that's now they might see through his bullshit. We'll see. But it does make a big difference if you got somebody who's good at speaking and somebody who's not good at speaking. That will tend to not make the argument, but certainly in a debate format, the person who's better at speaking will often be perceived as making a better argument. That's just basic psychology, unfortunately. It's not here to argue that it's right or wrong, just that it's really basic human psychology, and it's a well understood phenomenon. So, is that going to make or break Kyle? I don't know, but it doesn't help him, and anything that doesn't help Kyle, I want to point out as a problem. All right. So let's see here. Now Richards did get better. So like I said, he was pretty rough the first hour. It seemed like his arguments were all over the place. Not that his arguments were all over the place, but the things that he was addressing were kind of all over the place. Some of that has to do with the way the state kind of birdshotted rather. Now that's completely screwed up that analogy. Birdshotted the charges, which is throwing out so many different charges, all of them having 3+ theories as to how they happened, and having all of these different things that they've purported that Kyle did, and none of which holds up. But because there's so much stuff to respond to, that's part of the reason why Richards had to kind of be a little disorganized in his closing statement for the first hour. Now, certainly, I think that he could have done it a lot better. Maybe they should have hired a speechwriter or something. But I guess that is what it is. Not really much we can do about it now, but I know that it was noticeably rough. It was noticeably difficult to listen to for the first hour. That, this guy's defending Kyle, and man, he just doesn't sound like he knows what he's talking about. He sounds a little angry. He's, rah, Kyle murdered people, and it's just like, I don't know if this is going to play well with the jury. So I guess we'll find out. he kind of got into stride after he got through about the first hour or so. Like I said, his initial statement for the closing arguments was about an hour 40 minutes, and he finally got into stride into the second hour. He actually, in responding to the first-degree reckless endangerment charge, which includes Richie McGinnis, which is one of the charges Kyle's facing, is that he recklessly endangered Richie McGinnis's life. Now, I've spoken at length about my thoughts about what Richie McGinnis was doing in that moment and whether or not it's appropriate for Kyle to have received that charge. I would say that the defense agrees with me that, quote, Kyle is not responsible for Richie's safety in a riot, and it's Richie's responsibility to keep himself safe. So it's not up to Kyle to not recklessly endanger Richie. Richie's knows what he's getting into, and it's not Kyle's problem. And I agree that's not Kyle's problem. Kyle did not do anything to intentionally endanger Richie. If Richie found himself unintentionally endangered by Kyle's actions, that is Richie's fault. That is Richie's problem, not Kyle's problem. Kyle should not have been charged for that. Let's see here. Oh, thank you for the follow, Susan. There we go. Timberwolf. Wait a minute, Fox. Where are his sights on his gun? Okay, so they did remove his sights from his rifle when it was brought into evidence. The sights, I believe, are also there as a separate bit of evidence. But yes, this isn't the state like making up like a new rifle or something like that. Like that is Kyle's rifle. It just has the sights taken off of it. That was discussed earlier. And I don't remember the reasoning for it. But actually, it'd be interesting to allow the jury to play with the sights because the state has continued to allege Kyle pointed a laser sight at Yellow Pants. I don't want to go through the explanation Yellow Pants is. If you've been watching the last 10 days, great. If you haven't, I can't help you at this point. But Kyle's sight is a red dot, which casts a holographic laser, which can only be seen inside the glass. It can't be seen outside the glass. It doesn't actually send light out the front of the rifle to actually physically land on somebody. The light only exists inside the lens holographically. Only you can see it if you're looking through the glass. An actual laser would actually send out a beam of light from the end of the rifle, and there would be an actual visible beam of light no matter where you were standing that actually really existed on the person that you were pointing at. A bunch of the rioters, including Yellow Pants, alleged that Kyle pointed a laser, that he was pointing his rifle at him because they felt laser light, or they saw laser light land on them, and they assumed it was Kyle taking aim at them without any evidence. But Kyle's rifle, his sight is a red dot. It can't generate a beam of light that leaves the rifle. The beam of light only exists inside the sight, inside the glass, and it doesn't actually create a visible dot on any person. So I really think the defense should just let the jury play with the sight and see if they can get a laser to shoot out of it, which they won't be able to do. Let's see here. The defense brings up this excellent point that the state wants to pretend that Kyle went through this elaborate scheme, this elaborate premeditated scheme to become famous, as per his TikTok bio, and that he was there that night in Kenosha to hunt human, the most difficult prey, to hunt humans and to murder people. Now, this is unsupported by any evidence, but the defense makes a wonderful argument about this, that if Kyle was really there to be a active shooter, the state keeps using this term active shooter, which the defense references specifically and explains to the jury. The state is using the word active shooter because the word active shooter has this connotation in our current society as somebody who represents an ongoing danger and is there to hunt down people and to cause havoc. Though Richards pronounces havoc very oddly. I don't even think I can pronounce it the way he does, but either way. Again, it's the state's position that Kyle played Call of Duty. They asked him about this on the stand, that Kyle played Call of Duty, and isn't it true, Mr. Rittenhouse, that one of the goals of Call of Duty is to use AR-15s to kill everybody around you? That is essentially what the state's alleging Kyle was trying to do, was reenact Call of Duty. Now, if this was true, that Kyle was there to just kill people, he did a pretty bad job of it. Kyle's defense points out that after shooting Rosenbaum and running towards the police, Kyle ran a full 2 blocks before he engaged or was engaged by additional rioters, throwing rocks at him, hitting him with a skateboard, and Gage attempting to point a Glock at his head. So, if Kyle was there to shoot and kill people, why did he wait 2 blocks and get closer to the police before he started shooting people? That doesn't make sense. They say Kyle was there to kill as many people as possible, but he had 30 rounds in his magazine and he only shot off 8. He's not a very good mass shooter. He's not a very good active shooter, if that's indeed what he was. And so I think this is pretty compelling. I think it's a pretty compelling defense or counter to what the state said. The state wants to claim that he's an active shooter. Okay. Where's your evidence? There doesn't appear to be any evidence that he had any intent to actively shoot people. The only people that he shot were actively engaging him, actively attacking him, actively feet away or closer, attempting to do him harm. If he really wanted to do some damage, he certainly could have. Another thing I didn't write down, but I'm now remembering, is Binger bringing up the full metal jacketed hollow points, how these are designed to over penetrate, and that these are bullets that are designed to go through their target and hit other targets, which I don't think that's true, but I don't know. But the defense brought up that he's been a lawyer for a long time, and he's been in other murder cases where the state says that if Kyle had loaded hollow points, then he wouldn't have been recklessly endangering other people, because the hollow points get stuck in the first person you shoot them in, which isn't necessarily true. Also, I'll point out that Kyle's jacketed hollow points, his super bullets, which is something else the defense said, which I'll get to in a second. One of Kyle's super bullets actually didn't go all the way through Rosenbaum. It actually got stuck in Rosenbaum, so that's not necessarily true either. That the full metal jacket bullets, that those always leave the body, just isn't true per the state's evidence, and that the hollow points never leave the body is also not necessarily true. But the defense tackles this and explains to the jury that Binger's trying to create this weird specter of full metal jacket bullets, like as if there's some kind of super bullet that only like elite executors and snipers use, and it's just not true. Binger had said that Kyle had recklessly endangered people because he intentionally chose to use full metal jacket rather than hollow point, and that was an intentional act because Kyle meant to recklessly endanger people that were behind the people he was shooting at, which wild speculation. However, the defense counters it, saying that there's plenty of cases where using hollow points has been seen as that is the aggressive act, that is the reckless endangerment, because the hollow points specifically do more damage to the person that you're shooting at, and that he's been in other cases where the use of hollow points has been seen as bad for the shooter because, why did you intend to do so much damage to the person? You could have used a jacketed full metal jacket that would have passed right through him and not caused as much damage. And then now it's the reverse where, had you caused more damage inside Rosenbaum with an exploding bullet, then, that would have been not recklessly endangering. And basically the defense says, at the end of the day, a bullet is a bullet. Even though Binger said in his previous closing statement that bullets are not bullets, some bullets are different, which I guess that's true, but at the point blank range that Kyle was firing all of his bullets, a bullet is a bullet. I would say most of the people that Kyle shot, I would say that they died due to the shockwave of being so close to the muzzle rather than the bullet that went through them. At that point, I don't think it matters what you're shooting them with. I think you could probably shoot them with blanks, as we know from certain movie actors. You could probably shoot them with blanks that close, and it would probably nearly kill them or have nearly the same results. So Binger's contention is that bullets aren't just bullets. Some of them are different bullets, and you're just dumb and not thinking if you think bullets are all bullets. And then the defense steps up and goes, actually, bullets are bullets, which I think is true. Certainly, different kinds of bullets do different kinds of things, but at point blank range, bullets are bullets. And really, you're just getting the concussion wave that's causing injury at that point. I would say the bullets are really incidental at that point. Whatever. Binger's an idiot and a dork. All right, so then the defense, like I said, not as well spoken, kind of wandered in his closing a little bit. He made some sarcastic references to the state editing images, which I understood because I've been following the case. Obviously, the jury's been following the case, but I've been following the case kind of like outside the case as well. And also, I've had the luxury of seeing interactions between the judge and the lawyers between the times the jury are there. The jury hasn't seen. And so Richard's making sarcastic references to these blown up, foggy images and these pixels being expanded out. I understand it, and it's funny, but I don't think that it plays with the jury because I don't know that they have enough context to understand why it's funny. Also, I don't know that saying something ironically is the correct tact for a closing argument. You've got a limited number of words that you can say, right? So Kyle is going to go to jail for the rest of his life or go free for the rest of his life based on the words that Richard says in the next 2.5 hours. I don't know that you want to waste words on being ironic by saying words that are the opposite of what you mean, but hoping that the jury picks up your dual meaning in the tone of your voice. I don't think that's a good strategy. I mean, it's certainly funny. I'm sure it played well on Twitter, but I don't know. I was not excited to see him do that, and I was a little confused as to why he chose to do that. Let's see here. He said, which this was good, that even Gage Grosswicks testified that Anthony Hubert and Jump Kick Man, that Gage was concerned that they would injure Kyle. So when Gage was lying during his testimony, he said the reason why he ran up on Kyle was because he was concerned for Kyle's safety, because he was concerned that Anthony Hubert might have hurt Kyle with the skateboard, and he was concerned that Jump Kick Man might have hurt Kyle's head with his boot. And so, if even the state's star witness is concerned that Kyle was going to get injured by Jump Kick Man and Anthony Hubert, then all of a sudden Kyle has reasonable cause to shoot them in self-defense because there seems to be this imminent threat of bodily injury. Let's see here. Richard's made some more sarcastic references, actually sarcastic enough that I did not actually know what he was talking about, which I thought that was pretty, again, limited number of words, 2.5 hours worth of words to decide Kyle's next 90 years of life. I don't know if you want to waste those words on sarcasm. I especially sarcastic enough to the point where I didn't know what he was talking about, and you guys know how much I've been following this case. So, then let's see here. Richards starts digging into the explanation of Kyle shooting left-handed, whether or not he would be shooting left-handed with the rifle in the image that the state was showing. Again, Binger showing a grainy image and telling the jury this blob of pixels is really Kyle holding his rifle left-handed, and then Binger reenacting that by holding the rifle right-handed. The defense picks up on that and shows, hey, Binger showed you the wrong way, but here's why Kyle couldn't hold his rifle left-handed, is because the brass gets ejected out the side, and so if Kyle was holding it left-handed, it would hit him in the face, and that explains why Kyle couldn't hold it left-handed, which is the worst explanation for why Kyle wasn't holding it left-handed that I ever have heard. Warrior Poet Society, who, if you don't follow Warrior Poet on YouTube and everywhere, social media, highly recommend it. That guy is a genius, brilliant, amazing channel on gun stuff, but also just America. He did a fantastic 30-second explanation of why Kyle couldn't have gotten his rifle left-handed. And it has to do with, in the image that you're seeing right now on the screen, the way Kyle's sling is set up in a right-handed configuration. And Warrior Poet actually says this is a problem with having your sling set up like that, is you actually can't get your rifle into a left-handed position because the sling would prevent you from doing that. It would get yourself tangled. Now, I can't explain that verbally as well as he shows it on camera, so I highly recommend that you go to his channel and check him out, and he'll do a full explanation of it. That was a unique explanation of why Kyle couldn't hold his rifle left-handed in that moment without taking his sling off and completely repositioning it, which we don't see him doing. We see him seconds prior and much higher definition video that his sling is still in a right-handed configuration, and we don't see in the video, there's not nearly enough time for him to have taken his rifle off. We don't see nearly the amount of arm movement that would be required to do that, to take his rifle sling off his body and to reconfigure it. And in fact, we see him in later videos, especially with Anthony Hubert, where his sling is still in a right-handed configuration. So unless he switched it to left between frames and then switched it back to right between frames, then he was never holding it in a left-handed position, because the right-handed configured sling would have actually prevented him from moving the rifle into that position. So Warrior Poet does a great job of explaining that. But the explanation that Kyle couldn't hold it left-handed because the brass would have gotten ejected into his face, one, it's only sort of true. Two, it's not a great explanation, because if you are in a life and death situation, if you get some hot brass hitting your face, you're probably not going to care. It's not a good explanation. So, odd way of explaining that. For the defense, I would have maybe gone with the Kyle's right-handed. We never see him holding it with the right hand, but certainly the explanation from Twitter would have done a much better job defending Kyle. Unfortunately, it would have appeared to me, kind of my hot take on it is that Binger's closing argument was essentially Twitter's closing argument. Binger was an avatar of all the worst things Twitter said about Kyle and all the stupidest propositions they had explaining Kyle's actions that night. Binger's testimony was just a recitation of Twitter for the last 14 months. Just hashtag Rittenhouse, Twitter. That was that was Binger's closing argument. Richards, on the other hand, counterintuitively, if he had done Twitter's closing arguments for the defense, it actually would have been a lot better. So I don't know if, mostly because it's true, right? So that's the weird thing about the right and the left, is that the big difference is that we're right. But Binger doing Twitter's closing arguments, I thought that was been well disproven. Why did I think it was well disproven? Well, because Kyle's defense on Twitter has been disproving it rather adamantly. And by Twitter, I stand in for all social media. So if Binger wanted to do these social media closing arguments, that's fine. But really, Kyle's defense would have been potentially much improved by using Twitter as their closing arguments. I believe that Twitter did much better explanations than the defense did as to what the problems were with the state's videos, what was wrong with their edited photos. They did a much better job on Twitter doing that. Twitter and YouTube did a much better job of explaining why Kyle's rifle couldn't go the other direction. They did a much better job of breaking down these certain key frames that the state was trying to say that this makes and breaks the case. I don't know. I was not as excited about the closing testimony for Kyle. I think I could have possibly done a better job. I don't know. I guess we'll find out. So that is what I've got for what I watched up through. There were certainly more Richards closing. It was rather boilerplate. I thought he kind of went through each witness and kind of individually debunked or confirmed certain things that they said. I thought that was rather compelling. Just going through with the jury, reminding them, refreshing their mind that, most of the case for the defense was made by the state's witnesses, which is true. And then Richards had some strong finish with "This is not a game." He had some other strong quotes there, which I'm sure I'm forgetting here. Again, I'm coming to you seconds after he finished his first segment. And then, after Richards was done with his first part, the state got to rebut. They should have had about 20 minutes to rebut, followed by Kyle's defense rebutting for, I think they would have had almost 50 minutes left to rebut that. And then they would have given it off to the jury. Now, presumably some of that stuff has happened by now, but I haven't watched it because I was streaming with you guys. So, at this point in the show, we are going to watch the remainder of the closing arguments because I haven't seen them yet. So if that's something you guys are interested in watching, I'm just going to kind of sit here. I'll probably do some light commentary because I won't be able to help myself. But why don't we see what happened? Highly fascinating start with the judge just staring at his iPhone. We'll play this at a little bit faster speed here.
Thank you, Judge.
So this is the state going back.
It simply cannot be reasonable for someone to be holding an AR-15 semi-automatic rifle with powerful ammunition and be chased by someone who is unarmed, who's smaller than him, who's shorter than him. And the first thing that you do to defend yourself is you plug 4 rounds into it. You shoot it from about 4 feet away, and not from 4 feet from Mr. Rittenhouse, 4 feet from the end of that gun. Your first shot immobilizes him. It shatters his hip. Then he's caused to go forward. And if you watch the videos, and we're going to watch a couple during this brief rebuttal, he crumples. He immediately crumples to the ground. No one is saying that Mr. Rosenbaum should have chased Mr. Rittenhouse. No one is saying that Mr. Rittenhouse did not have a right to defend himself. This case is about the right to use deadly force. And I want to talk about that standard because Attorney Richards, perhaps on accident, misstated it. He said that the standard is that it could cause death or great bodily harm to Mr. Rittenhouse, or that it is likely to cause death or great bodily harm to Mr. Rittenhouse. That is absolutely not what the standard is, and that is not what this trial is about. The standard is the defendant may intentionally use force which is intended or likely to cause death or great bodily harm, such as fire an AR-15, only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to himself. Not, if you repeatedly smash someone's face, it might lead to injury. Not, this could have happened. Imminent death or great bodily harm. There's an old phrase that I could kill you with my bare hands. And there is literally no evidence that Mr. Rosenbaum was capable of that. Mr. Rittenhouse has size on him. We heard how he's a swimmer. We heard how he's a lifeguard. He's apparently in some kind of shape. Punch him in the face. Kick him in the testicles. Knee him in the face. Hit him with your gun.
That's
you
ridiculous.
Don't just immediately get to shoot someone. And I don't care about provocation or any of that. Put
You
that
actually
aside.
do.
It is not reasonable for any adult, for any person, for any 17-year-old male to not try and defend yourself first using other methods. Now you factor in provocation, the fact he had no right to retreat, or no ability to, or he had to retreat, and that he had to exhaust all methods. Clearly, if there was provocation, he's guilty. But even outside of provocation, why do you get to immediately just start shooting? As Mr. Binger said, he brought a gun to a fist fight. And he was too cowardly to use his own fist to fight his way out.
Wow. He was too cowardly to use his... Wow. that might have lost them. That might have lost the state. I can't imagine the jury. That's wow. Coming from that guy too, Kyle was too cowardly. That was Kyle's problem. Is that Kyle was a coward. As we know, the left likes to say, the guns are the coward's way out. Whew, man, I will be surprised if the jury likes that. I would imagine that's probably not real high on the jury's. I would think the jury wouldn't like that very much. That's pretty aggressive. That's a pretty aggressive thing to say, especially after Binger had earlier called Kyle a rat, pathetic, and a sniveling 17-year-old. Okay.
He has to start shooting Bill retreat, and that he had to exhaust all methods. Clearly, if there is provocation, he's guilty. But even outside of provocation, why do you get to immediately just start shooting? As Mr. Binger said, he brought a gun to a fist fight. And he was too cowardly to use his own fist to fight his way out. He has to start shooting. And let's just say, theoretically, that the 12 of you think that it is reasonable to have used force, deadly force in that situation. Shoots once, takes out his hip. What does Mr. Rittenhouse have to do to avoid that? Well, maybe take one step back. And Mr. Rosenbaum is no threat. And Mr. Rittenhouse is responsible for every round of that gun. It did not have to happen as fast as Mr. Rittenhouse made it happen. He could have held back at one shot. He could have held back at 2 shots. The guy in the blue hoodie who came in to attempt to kick him didn't get 4 shots. Mr. Rosenbaum didn't get 4 shots. And Mr. Gross-Kreutz did not get 4 shots. The defendant has the ability to gauge what he is doing and to stop shooting. Mr. Richards talks about the threat being immobilized. What threat does someone 6 inches shorter than you that you've already shot in the hip and is already falling to the ground have? Why do you have to keep tracking him and shooting him and ending up with a kill shot in the back?
Well, if the state had allowed the evidence that Rosenbaum had brutally raped a bunch of children,
Mr. Rosenbaum
a bunch of toddlers,
and Mr. Rittenhouse are alive. Because the defense talks about games that the prosecution has played. Let's talk about games. Let's talk about how Mr. Rittenhouse on that night did not tell Dominic Black, did not tell Joanne Fiedler, did not tell anyone about this grabbing of the gun. Didn't tell anyone about, I was afraid they were going to use the gun against me. That is because once Mr. Rittenhouse and his team understood that an unarmed person chasing him and unarmed people chasing him later on would not be enough to meet this standard, to meet this privilege, they had to concoct a story. They had to concoct a story about how suddenly I was in great fear of this gun being used.
Oh,
and if that's the real reason, why didn't Jason Lukowski know that? Why didn't Dominic Black know that? Why didn't...
Also, if you're on YouTube, I would recommend going over to dlive.tv/direwolf. I've heard that YouTube has been a little aggressive on the copyright strikes for these, even though this is a public broadcast. It's a little ridiculous that they'd be striking channels, but due to my lack of commentary, we may be slated to get taken down here midstream. So head on over to dlive.tv/direwolf if you want to continue listening uninterrupted.
And Joanne Fiedler know that. You darn well know if there was any evidence of the defendant saying that the night of, we would have heard about it. So yes. Mr. Rosenbaum is 4 feet or so from the barrel of the gun. He gets shot in the hip. He begins to crumple. Now remember, we did this demonstration when Dr. Kelly testified. This bullet entered here in the middle finger and came out here. This is how you grab something. I'm Mr. Rosenbaum trying to take this gun away. And this is how I'm going to do it, with my hand turned almost completely around, and with apparently my fingers spread, because these 2 don't get soot, which may mean they were on the gun or outside of the path, and the other ones do get soot. We're not talking about injuries to the palm here. We're not talking about injuries like this, or any kind of grabbing injuries. We're talking about either something accidental or completely defensive to knock that gun away as he is being shot just before he is killed on the 3rd or 4th shot. Well, we're supposed to believe that Mr. Rosenbaum is Jason Bourne or John Wick or some other movie star hero who's capable of killing with his bare hands and deserved the treatment that he got from the defendant.
What?
Mr. Richards' closing was quite personal. If not taking shots personally, Mr. Binger, he was gloating and boasting about his client's kills. And he talked a lot about the Zeminskis. He knows darn well that the Zeminskis are charged by my office and they have a 5th Amendment right. This is a criminal defense attorney.
Stop.
Ooh.
Stop. Let me ask you to step out for a moment, would you?
Ooh, what's going to happen here? Okay, well, I'm going to roll back here and see what he said real quick, because I think I might have missed that.
was quite personal. If not taking shots personally, Mr. Binger, it was gloating and boasting about his client's kills. And he talked a lot about the Zeminskis. He knows darn well that the Zeminskis are charged by my office and they have a Fifth Amendment right. This is a criminal defense attorney.
Stop. Stop. Let me ask you to step out for a moment, would you?
Uh-oh. I don't know what let's see what this issue is, because they're about to get in trouble again. Oh boy. Judge about to lean into them. So
What's your objection?
It's not in evidence, and Mrs. Zeminski doesn't have a right. Her case has been disposed of, and she did not appeal.
She did not plead or was charged with any arson, which the defense could get into, and she would have a Fifth Amendment right.
As I recollect, I think I handled the case. As I handled the case in...
Joshua Zeminski?
What's that?
Joshua Zeminski?
That's pending.
Right.
Mr. Zeminski's case is pending, and it has been repeatedly adjourned to follow this case. At the state's request. I handled the case of Mrs. Zeminski, and she came out on a reduced charge. It was a recommendation, I think, for a 7-day sentence.
She was being revoked and sent to prison. I don't know the particulars of that case, but if Attorney Richards,
well, she wouldn't have a right of. I think I sentenced her to 7 months in prison consecutively to her sentence, and I don't think. Why would she have a testimonial privilege any longer?
If there are charges outside of what she was charged with, she wasn't charged with any arsons.
Are you going to charge her?
I don't know. Probably not.
All of the charges out of the event were wrapped up. They can't piecemeal the charges, and to argue that she has a Fifth Amendment right now is ridiculous.
I did say Mr. Zeminski had a Fifth Amendment right, and then the objection came. I did not say Mrs. Zeminski. I can clarify that Mr. Zeminski has a Fifth Amendment right.
Well, let's find out from the report of what was said. I thought it was just Mr.
So basically, the state gets to charge the Zeminskis. The Zeminskis get to claim certain privileges under the Constitution within the Rittenhouse case, but it's dependent on what the state charges them.
I think you said that Zeminskis are charged by my
The
office, and they have a Fifth Amendment right.
Did you say the Zeminskis? Both? All right, well then,
I'll clarify.
I'll sustain the objection.
I understand.
All right. Ask the jurors to come back in, please.
Yeah, basically the state gets to choose who they're charging with what, and then based off of that, the defense has the option to call them for testimony. But because of the way the state chose to charge the Zeminskis, the Kyle's defense was unable to call the Zeminskis as witnesses, which is the state getting to kind of tilt the board in a certain direction in their favor, which is inappropriate. Yeah, glasses guy. I didn't really like the tone that Richards used. I said that earlier. That
I sustained the objection because the statement, which was made by Mr. Cross, was not accurate.
I thought his
at least
tone and
as
tenor
regards,
wasn't.
Mrs. Zeminski. Any question?
Was definitely
Go
a
ahead, Mr.
gamble.
Cross.
Ms. Zeminski was charged and convicted by my office. Mr. Zeminski still has pending charges. Attorney Richards knows that he has a Fifth Amendment right to not testify.
Let me ask you to step in the library again, please.
Wow. Wow. Yo-yo jury. I didn't know this was going to happen. This is good TV. Jeez. The state is just doing every dirty trick in the book, or they just don't know how to run a trial, but these are supposed to be experienced attorneys.
Your Honor, it's not in evidence. Two, one, wait for the door. One, it's not in evidence. Two, if he wants to say he has a Fifth Amendment right, they also can grant him immunity. They're the only people who can. And if they're going to say that, I should have a SIR rebuttal to explain it to those 12 people. They hold the keys to Mr. Zeminski testifying or not testifying.
We just heard 2 hours of how terrible Joshua Zeminski was, and the defense wants us to offer him immunity. That's completely
That's not
our
what you
decision.
said, Mr. Krause, please.
He still has a Fifth Amendment right. What I'm saying is accurate.
But you know, the question you're asking, the Zeminski case has been here on a number of occasions, and it has been it's been a mutual request to adjourn the case. Who's his lawyer?
Mr. Barth.
Okay, it's been repeatedly requested that it be adjourned, and I assumed, or was told, I'm not sure which, it would be adjourned pending the outcome of this case. No, that's not true?
No. I don't know.
Well, it's not true. It is true that I assumed it. Whether I was told that or not, I don't know.
It's not the same as Almanac Black, Your Honor. It's a different situation. Mr. Zeminski's case will go to trial on January 31st.
Well,
That's the plan.
but why was it being adjourned?
I think there was some, we had a witness who was not available at the last trial date, so we needed more time to get them in.
Okay. And Mr. Richards also brings up a point that you have control over the availability of a witness in terms of grant of immunity, but I don't want to get into that because I think on the first point he made, which is that I don't think it's an evidence.
I asked Mr. DeBruin about it.
What did you ask Mr. DeBruin?
I asked Mr. DeBruin that when we were talking about our meeting, that he was going to be a witness against Mr. Zeminski, and that Mr. Binger talked to him mostly about Mr. Zeminski because there's a pending case against Mr. Zeminski.
Say again.
After Mr. DeBruin talked about our meeting, on cross-examination, I asked Mr. DeBruin, I believe this was a while ago, I indicated that he was going to be a witness in the Zeminski case, and that Mr. Binger asked him mostly about Zeminski, and why would Mr. Binger ask questions about Mr. Zeminski in an effort to change his statement in the Rittenhouse case? And he had no answer for that.
What's that got to do with the
Fifth Amendment right.
that the district attorney is making, or the defense attorney is making?
It's that there's an open pending case against him.
There was specific testimony that there was a trial date on January 31st. That came in through Mr. DeBruin, and I actually mentioned it in my closing because it's in evidence that there's a pending case. I'm prosecuting Mr. Zeminski, and the trial's coming up in January. That is in evidence, Your Honor.
It has nothing to do with the Fifth Amendment, which is what I'm objecting to, and bringing that into this.
I don't know.
Okay, so Kyle's defense
You're making it
wanted to.
sound as if, well, you're making it sound incorrectly so, that Mr. Zeminski.
So Kyle's defense wanted to bring Zeminski's in as testimony to show that they had some association with Binger or with Rosenbaum. They were unable to do this because Zeminski's have a pending trial, and so they can claim Fifth Amendment rights to not incriminate themselves in Kyle's trial. However, the only reason why they have a pending trial is because Binger kept their trial open when Binger had the opportunity to complete their trial at an earlier date, and it seems like perhaps they're playing games to keep certain witnesses wrapped up in trial so that they were unavailable for Kyle's trial. I think that's what's going on here.
Fifth Amendment, which is what I'm objecting to, and bringing that into this.
I don't know. You're making it sound as if, well, you're making it sound incorrectly so, that Mr. Zeminski is unavailable because of his testimonial privilege. But now Mr. Richards is asking whether he should be allowed a rebuttal to, so the jury would understand that that is somewhat under the control of the district attorney. But I'm not going to, at this point, I'm not going to get further into that. I'm just going to ask you to move on to something else.
Well, my next line of argument is that the defense named them in their witness list and could have called the Zeminskis.
No, he can't because he's got a Fifth Amendment privilege for the very reason you indicate, and privileges must be claimed as much as possible
There we
outside
go.
the presence of the jury. That's the statute.
They could have called Kelly Zeminski. They admitted her here from prison.
So
Pardon me?
we had to have her available in case something came up. That doesn't mean we have to call her. We have no obligation to put anybody on the witness stand.
Nor does the state. And
The state is-
Mr. Richards commented many times about how we could have called them, which I think was dishonest given the Fifth Amendment issue. But then also I can mention that when he set up and read his witness lists, the Zeminskis were on it, and they have the ability to call them as well.
The witness list is not in evidence.
These are opening statements, and he commented on those multiple times.
State is trying to play games. Yeah, that's exactly what I thought it was. State's trying to play games by keeping Zeminski's trial in play so that the Kyle's team couldn't call them. And then now they're trying to say, well, you could have tried, but it wouldn't have worked. This is interesting. This is, that's weird that the state gets to... They should have pulled in a special prosecutor then. Binger shouldn't have been allowed to prosecute all these people if these cases conflict with each other. That's a massive...
What was the last statement you made now that drew the objection?
Massive miscarriage of justice.
That Mr. Zeminski has an open case and a Fifth Amendment right.
Yeah. Well, that is an accurate statement.
Then I should be able to fill in the holes because they're the ones who can give them immunity. I can't call them.
Well, I know that, but
Now they're trying to...
you know. You can
He was saying
no,
opportunities.
no. You address your remarks to me, both of you. To me, not to each other, please.
It's called being prepared. I don't know what's going to happen at a trial.
Okay. Well, I think I'm just going to tell the jury that Mrs. Zeminski would have been available to be called by either party. Okay?
Fine.
Fine.
Oh, man, I got out of it alive. Okay. Have something come in, please.
Yeah, so the state wants to try to pretend that the Kyle's defense not calling Mr. Zeminski is incriminating to Kyle, but the reason why they couldn't call him is because the state hasn't given them immunity, but the jury doesn't know that because it would, for various procedural reasons, the jury can't know why they weren't called, but the state's going to allege that Kyle's defense didn't call Zeminski because, I don't know, I guess it would have incriminated Kyle. I don't know. They're just going to use that as kind of a just kind of a MacGuffin to purport all these things about Kyle's defense that aren't true.
All right, folks, what the situation is that Mrs. Zeminski would have been available to either party to call as a witness, and neither of them.
But she's not the one that fired the
Any question?
gun. Mr.
Go ahead, Mr.
Zeminski is the
Thank
one
you.
that fired the gun.
Mr. Richards also mentioned that Attorney Binger talked about how all these people are liars, and he was acting like a whiny defense attorney. I don't know why that language had to be used, but Mr. Binger never said any such thing.
Binger
He was calling
called
anyone
Kyle a
liar, except for
rat.
Perhaps Mr. Rittenhouse. And Mr. Richards talks about how, well, in the state's open, he heard nothing about provocation.
And
Mr.
this guy
Richards
just
knows
called Kyle
that
a
is a specific
coward.
thing, that instruction we get from the judge at the end of the trial. Had we mentioned at the beginning, he would have objected. He would have objected. Now let's talk about this threat, this supposed threat. Mr. Richards talked about that gas station and showed the video, and it showed Mr. Rosenbaum at the end. Attorney Binger had said he's not in this video as it started, and you don't hear anything from him. And that is true. At the very end, he is seen standing quite a bit away from Mr. Balch and Mr. Rittenhouse. This is where that supposed threat happened. There's a distance between them. Next time the camera pans back, the protesters are pushed back. And you never hear this threat. You hear nothing. And apparently that is what the defense is accepting, is where the threat happened, although Mr. Rittenhouse actually does not accept that, because he said it happened at Blocker 2 North. So they can't agree on when the threat took place. They can't agree on where the threat took place. And it's the only few seconds of that part of the night that is not on tape anywhere. It's another concoction to give credence or to give weight that, oh, he had to
It's also
defend
not
himself
on
against
tape
an
Kyle pointing his
unarmed man.
rifle at people, but
There's some talk about how the defendant came around that Duramax and raised his gun. That didn't seem to be a contested issue in the case until the defendant lied about it on the stand. The defense themselves submitted an exhibit, number 41, in which it is denoted where the person that put that video together indicates Rittenhouse pointing gun at Zeminski's. I think it has a question mark. This was their exhibit. There was testimony from Detective Antaramian, and we showed this drone video. Now, but then the defendant won't admit to it on the stand, and then all of a sudden the defense has to fight it and talk about hocus pocus and make up little clever rhymes. The defendant could have told you the truth, but that hurts his case, and that gives us provocation. Now, I did have, on rebuttal, Mr. Armstrong put in two very blurry pictures. Mr. Binger didn't even mention these pictures in his closing, because they're maybe the fifth, sixth, or seventh strongest pieces of evidence that Mr. Rittenhouse raised his gun.
they keep saying that, but it's
But the defense is
just not
seizing on
true.
them.
There
And they
is no
inaccurately
other
said
evidence
that it took him
Kyle
20
raised
hours of
his
work to
drone.
do. He worked on that drone video for 20 hours. He made us multiple shorter videos of it. These images were the last part of that work. And that image does show Mr. Rittenhouse holding a gun. It is blurry. Does it show every detail? No. But we thought it important that there at least be some still shot besides these videos. The second one I showed, again, is very blurry, but it's of the shooting. And you see Mr. Rittenhouse blurry, you see the puff of smoke, and you see Mr. Rosenbaum blurry, still very much upright. And that is why those pictures are given. It was the tail end of all the work that Mr. Armstrong did on this video. The defense seems very scared of these.
Wait a second. So is he saying now that the first shot Kyle sent, that Rosenbaum remained upright? I thought their whole point was that after the first shot, Rosenbaum was flat on his back or front or whatever, then Kyle started shooting him in the back. They change what they say happened depending on what point in time they're at, just in their narrative, just to make sure everything always fits up for them. But it just, none of it's like one explanation that they have isn't compatible with other explanations that they have, because they only work for certain details. And it's just, well, that's how lies work, I guess.
These pictures, because it helps to prove their client lied on the stand, and it shows that he provoked the attack. Now I would like to show you, I believe this is the full drone video, Exhibit 73.
I am playing this video at 1.5x, and it appears that we got about 30 minutes.
So in this one, it is
before
difficult to see
they
the raising
go
of the gun
to,
because it's the
like,
full video.
Just kind of scanning ahead here.
I
So
would encourage you, if you find it necessary, to take a closer look at the bigger TV. Please stop it.
probably about
Now, as you
30
see
more
in this
minutes
video,
of this.
Mr. Richards wants to make it seem like the only recourse the defendant has in retreating is walking into this mob of people who are breaking cars. But look at all that open space that he has. At this moment, he could have turned around and ran in that space and gone right back up Sheridan, and everyone would be alive and everyone would be fine. Instead, he decides to start slowing down and run into these cars in which he is supposedly trapped.
How
which have been being
dare
trapped
the
in Target
victim
parking
slow
lot.
down? Definitely his
As you
fault.
see, as we keep playing it, he goes around them no problem, and he goes right into this totally clear space that was available to him the whole time. He did not exhaust his duty to retreat. He did not exhaust all of his options. Now, I'm going to go to the video. I'm going to point something out. Mr. Bringer is going to play it again, and I'll show you. This is in relation to Mr. Richards indicated that no one that attacked or that went after Mr. Rittenhouse in the second incident observed the shooting. That is not true. This video shows the person that is referred to as Jump Kick Man leaving the scene, and we have another view as well from another video, but I'll point that out.
We cannot. It's not tenable to live in a world where victims must run into dangerous situations to escape their assailant.
Jump Kick Man for a year, he sees it.
We need national stand your
He's standing the
ground.
whole time, and he comes and he helps push the man in the wheelchair out of the seat. So he absolutely was there. He did see what happened. What's next? This is Exhibit 10. This is the Ford Fisher video. If you look after the shooting, it shows this individual pushing the wheelchair away from car source 3. There he is across the street, pushing the man in the wheelchair away out of the scene. Hello? This is a video you've seen before. It does look better on the large television, but this is where he comes into the screen. This is one of the videos that Mr. Armstrong cropped for us in his 20 hours of work. This is slowed down by 50%.
Limbo system, yeah. This is the worst rendition of Harry Potter I've ever
I'll point
seen.
it out up here, but I said it is better seen on the large TV. There he is pointing the gun. He's not close enough to the car to have that be a factor. He puts on the fire extinguisher and he breathes up. It is. Now do the next student. Oh, you got it? All right. You want me to do that one? Again, that really wasn't an issue at trial until the defendant lied about it. Now, Exhibit 84, this is another video that Mr. Armstrong did in his 20 hours of work. And this shows the chase, as you see him point. Mr. Rosenbaum does his jump. See the defendant slowing down, seemingly preparing to shoot. And look where that first shot is. Go back play one more time. This is the zoomed in image that will eventually was shown. Look how far he's not reaching. He's being shot in the hip and falling. And he goes immediately to the ground, and the defendant sees fit to keep shooting at him, although he poses absolutely no threat.
The idea that being within arm's reach of
Again,
somebody
4 feet
is
from the barrel of the gun, not from Mr. Rittenhouse
no
himself.
threat is ridiculous. If there's a single mother on that, if there's a single mother on that jury, it's not going to play.
I believe he made 6 of them all told. They're all in evidence. Here's a close-up of the final shooting. The puff of smoke is already out. He's already upright. He crumbles immediately to the ground, but the defendant keeps shooting him. So did Mr. Rosenbaum turn and get shot in the back that way? No, he was even less of a threat. He was falling face first on the ground with his hips shattered. So yes, he was shot in the back, and he was killed by a shot in the back, and it was the 3rd or 4th shot.
I mean, you can say it all you want. It doesn't make it true or make it on video.
Attorney Richards indicated that Nick Smith.
You see how like blatantly, brazenly, even that's a word the judge used, but brazenly they lie about what is clearly in evidence, like what the evidence clearly contradicts, and it really makes you wonder, like Kyle's incident being so well documented from dozens of angles with hundreds of hours of video documenting, 5-minute spans of time from just hundreds of angles. Like, that never happens. And so there's so much evidence for us to see where these people are lying, or that the state is lying about what Kyle did. And it really makes you wonder what happens in cases where there's not as much clear-cut evidence. How clearly, Binger and Mr. Lunchbox here are very, very adept at lying in the face of contradictory evidence. I think that appears to be their style, which is the only thing that they really know how to do, which is why they're doing it in this case. It seems that they're very comfortable with that. And so you got to wonder, how does this work when there's less evidence? When there's perhaps just as much contradictory evidence, but it's not video. And you don't have a Twitter mob either analyzing the videos for you. You got to wonder. And I think that my supposition that the legal system in America is irrevocably broken, it only has more and more evidence for that the more I see of this trial.
Called the defendant. Nick Smith did not testify to that. He was never asked. We don't know who called the defendant to go to that scene. And despite the fact that there's this madman out there who's such a threat and is going to kill the defendant, he just saunters down there all by himself. No problem. He's not scared. This threat, if it even existed, was not taken seriously. He's a babbling idiot, as Mr. Lukowski said.
Yeah, it wasn't taken seriously until Rosenbaum started chasing him.
Mr. Rittenhouse testified he didn't hear anything before he shot. He didn't hear this "fuck you." He didn't factor in the gunshot.
Kyle didn't shoot him until Rosenbaum was literally on top of him.
There is no evidence that Mr. Huber did anything
evidence
towards
of
that evening.
Kyle's restraint.
They talked about pushing a dumpster, picking up pepper balls. That was not evidence that was ever submitted in this trial. And I don't know where it comes from. No evidence that he told Gage Grosskreutz I had to shoot in self-defense. And Attorney Richards talks about how, well, Mr. Detective Howard testified in a certain way and how he didn't talk about the drone footage or anything. He knows we got the drone footage, surprisingly, after Detective Howard testified. Guns do not have handed. There's not a left-handed or right-handed gun. So, yes, the demonstration that Mr. Binger did is how it happened. The defendant was facing that way, picked it up,
is in a right-handed configuration.
The video show it.
You're going to get stuck.
Detective Antaramian reviewed it and saw it and testified to it, and it wasn't an issue until the defendant lied. Videos don't lie, but we know Kyle Rittenhouse does. He lied all that night. A lot has been made about how Gage Grosskreutz had an attorney. How hypocritical from a lawyer to hear someone criticize someone else hiring counsel.
Wow,
Mr. Rittenhouse isn't here alone.
They literally did that to two of the defense witnesses, where they actually got in trouble for that. They stopped the trial, and Binger got just roasted by the judge for suggesting that it was problematic for one of the witnesses, or for two of the witnesses, to have legal defense. That was a problem, and the judge says, no, you can't do that. It is their right to do that. Kyle's defense did not really question that much, not nearly as much as the way the state did, but they both did to a certain extent. But it's just rich that they would point that out here.
He has lawyers, and I apologize that the district attorney's office followed our interpretation of Marcy's Law, which is a fairly recent, especially at that time, constitutional amendment.
Mr. Richards, don't wag your head.
Gage Grosskreutz is not on trial. He followed the advice of counsel not to turn over his phone. Just as anyone who
he's not on trial because this guy in Binger didn't.
We got his whole video from that night. The defense has seen it. We have
for
it.
illegally carrying a firearm.
Text messages from 3 weeks before. They just want to try to dig up dirt because they think it's there, because the defense wants you to believe that these people got what was coming to them, that they were bad people doing bad things, and we should be proud and boastful of Mr. Rittenhouse for killing them. Gage Grosskreutz testified what he heard, that he heard I didn't shoot anyone, and Gage Grosskreutz acted on that. He then followed, he left Mr. Rittenhouse thinking that he was not involved in the shooting, and started going to the shooting of Mr. Rosenbaum before being told by others that saw it that he was the shooter, and then he returned. So Gage Grosskreutz relied on this statement of Mr. Rittenhouse. Let's talk about a rush to judgment. Mr. Rittenhouse turned himself in. Are you supposed to wait days, weeks, months to charge murderers who we know murdered people? It's a red herring, as Mr. Binger said. It's throwing up red herrings, false, hypocritical arguments, and attacks on those that Mr. Rittenhouse killed to try and distract you from the fact that he was not in imminent fear of death or great bodily harm, and he was not privileged to act how he did. We heard from Ms. Carrie Ann Swart. Now that Nathan DeBruin talked about jail, now we can try to smear Mr. Rosenbaum more, although there really is no dispute, or was no dispute, that he came from a hospital. He's carrying a hospital bag. Ms. Swart testified that she talked to the hospital about how he would be released, that he went to this hospital. She knew he was coming home from the hospital. She knew it was in the bag, and he showed that picture of it backlit against the fire, trying to make it seem sinister. She talked about how there are medical papers in there. And we did that image again. Mr. Armstrong did this image for us, where you can get a little peek in the bag. And I would argue you can see medical papers. Though that big image they see looks like rolled up medical records that you get when you're discharged from a hospital. And Ms. Swart testified that he was given medications that day. Perhaps they didn't work. Perhaps there was a bad reaction. I don't know. I'm not a doctor. But he was given that day. He could not get the ones for future days because things were closed.
Why were they closed? Because, I don't know.
Balch did not
Black Lives
testify
Matter
that he thought there was
burning
anything sinister
down
in the
Walgreens.
bag. He said he said something inaccurate at the time, but he said that he saw shampoo bottles in a water bottle. Mr. DeBruin. He did take some nice photographs, and he clearly wanted the world to know that he took some nice photographs. He's really more relevant to Mr. Zeminski. And he apparently, this is the photo of the bag, you can examine that further. Mr. DeBruin
the guy
must have some problem with police and DA's offices.
This guy...
He goes to the detectives, he doesn't give a
DeVruin testified that these two guys, this guy and Binger, tried to coerce his testimony to get him to change his police statement, which these guys need to be investigated for that accusation. That accusation can't just sit there. They need to be investigated for that for sure.
The full story. He says, he testified to this. This is not me saying
He's
anything. He forgot this. He was so nervous because the door of the police station still had an unrepaired window. That caused him such nervousness that he could not give a full statement. He meets with us in a very polite, short meeting. He has very little relevance to this case that we knew about. And yes, we showed him some videos. Is this Josh Zeminski? Oh, no, it's not. Okay, would you see him in these other pictures? Yes. You don't know it's Josh Zeminski? Okay. Somehow that's us getting him to change his statement. What's that? We show him pictures, videos, say, is that Josh Zeminski? I don't know. We show him other pictures. Do you recognize that as the same person? Yes. That's not going to change his statement. We had him read a statement. Do you have anything to add to it? No. The next day, he goes over to Mr. Richards' office. All of a sudden, he knows all this extra information that wasn't in his statement. Oh, but he was so nervous meeting with us because we showed him a video or photograph that he took of Joshua Zeminski. And then what does he do? He goes and hires a lawyer very closely connected with a gossip blogger who attacks my office on a regular basis.
Now they're
and he was very
attacking him
pro-Rittenhouse.
for getting a lawyer,
Another
which they
funny
just yelled at
coincidence
the
in this case,
defense
just like
for
how
saying
Mr.
bad
Hernandez,
about
who doesn't
their
live in the
witness.
state, could hire any of the thousands of attorneys in Wisconsin or tens of thousands of attorneys in the state. But no, he hires an attorney who Kyle Rittenhouse's defense team has already paid money to that firm. What a coincidence. So Mr. DeBruin doesn't tell us any information, then tries to attack us, and then tells the defense a lot more information. Mr. Rittenhouse denied pointing a gun at the yellow pants man, said he was being sarcastic. Well, Mr. Richards basically just admitted he did point the gun. So which is it? We know that Mr. Rittenhouse was going around that night trying to be a paramedic, a policeman, and a fireman without receiving any real training in any of them. Tough job to do all three at once. And he went around with his gun trying to scare people, to intimidate them, to not do minor property damage. He's a chaos tourist. He was there to see what was going on, act important, be a big deal. And then the moment a little bit of that chaos comes back at him, he cowardly shoots a man instead of fighting back. You put yourself in this situation, you know it's going to be out of hand, it gets a little out of hand, someone is chasing me, and you have to shoot him. That is not privileged. That is not reasonable. And that is not what any reasonable person in the defendant's shoes would have done. We kept hearing about this rock in his hand. There's no evidence of there being a rock in that hand. Now, there's talk about how the defendant maybe have re-racked his gun. We don't see that in the video. We don't know what he did. But we do know that as Gage Grosskreutz is sitting there with his hands up, the defendant turns over his gun and is looking at it and is doing something with it. The defendant admitted to this, that he looked at the gun. Fully reasonable that Mr. Grosskreutz could have assumed that he was re-racking and preparing to fire. And it does not mean that an unspent shell casing has to be on the ground. Officer Bray testified that she shot AR-15s. She knows AR-15s. If it jams and there's an unspent shell casing, the re-racking will take out the unspent shell casing. It does not have to be a live round. I don't know what he was doing with his gun, but it's certainly reasonable for Mr. Grosskreutz to interpret it that way. And then what does he do? He doesn't step back and take a firing position and shoot. He didn't shoot him 5 to 6 seconds earlier when Mr. Rittenhouse was being an active shooter, after having killed his second person and shot at his third. He would have every right to have stopped Mr. Rittenhouse's activities at that point. But he didn't. He came up closer, he surrendered, and he said, He believed his surrender was not being accepted. Who shoots someone like this? Is he trying to shoot his own hand off? He never does anything about an actual position to shoot that gun. And as Mr. Richards admitted in his closing, when it's pointed at his head, his arm is already blown off. We're supposed to be so scared of Mr. Grosskreutz with his Glock when the defendant is holding a loaded AR-15.
Yes, because at point blank range, it makes a fucking difference.
That, Kelly Zeminski is holding a flashlight. It must be to bash heads. Certainly no one carries flashlights at night to walk home in the dark or walk to your car in the dark. I take my dog for a walk. I'm looking to bash in heads? No.
That guy does not take his dog for a walk. That's a lie. That is so obviously a lie.
We hear about how, this vicious kick that, if you watch it live, did not seem to make much contact, spun him 180 degrees. That is Kyle tracking him with the gun and shooting at him. He's moving as he's moving. That is not the force of the kick. And the video makes that clear. But again, we're grasping at straws and we're throwing out red herrings. And now, a skateboard is a deadly weapon. Someone should tell all the parents and grandparents and Santa Claus giving skateboards this Christmas about how they're giving their children a deadly weapon.
I mean,
I guess they should give them an AR-15 instead. It's just preposterous. And yes, Mr. Huber was acting heroic in holding down that and taking that skateboard and trying to hold him down and trying to take that gun. And what happened? The gun stayed attached to Mr. Rittenhouse. Because when the defense concocted this, they were trying to take my gun story, they left out that it is literally strapped to him. He shot an unarmed man 4 times because he was so scared that Mr. Rosenbaum was going to take the gun away from him when it was attached to him. It is an absolute red herring. It is an absolute ridiculous argument.
Well, no. You guys just testified that Rosenbaum was going to beat his ass.
Not, in 5 minutes after we get beat up, then I might be in threat. Imminent threat.
You guys testified that the closing arguments for the state was that Rosenbaum was going to beat his ass with a fist fight.
When you listen to the crowd as Mr. Rittenhouse is running, they start yelling after he's running when they're screaming, "Get him!" Also, as people are approaching him at the end, they're asking, "Why did you shoot him? Why did you shoot him?" These are people that were provoked because they witnessed an attack or heard shots or heard he was attacking, and they took action.
By that logic, then Kyle can be provoked by watching
the
summer of 2020 riots across all the country. But if the group can be provoked by an event they weren't a part of, then Kyle can be provoked by events that he wasn't a part of, like the
Kyle Rittenhouse is as strong ties to Kenosha, but he uses Google Maps to find a business he says he's driven by every day. He supposedly knows Kenosha so well and is such familiar with Kenosha that he doesn't realize you can walk 1 block either way to get back to the car source. He didn't want to go back to the car source. He wanted to go see what was going on. He wanted to stay in the action. He wanted to continue to do things that would make him feel big and make him feel important. These minor injuries we've heard the defendant have, again, Mr. Richards misstated the standard. It is not could have caused great bodily harm or death. It is not likely to have caused great bodily harm or death. It is imminent threat of death or great bodily harm. Where is that when you get a couple scrapes? Everybody takes a beating sometimes,
I'd say
right?
a violent pedophile,
a scuffle, and maybe you do get hurt a little bit.
5 small children.
That doesn't mean you get to start plugging people with your full metal jacket AR-15 rounds and no bullets are not bullets. And we heard testimony about that.
We did not hear testimony about the bullets.
Mr. Richards mentioned this
we heard
in opening,
Bigger
but
being
apparently he's noticed
idiot.
that the evidence doesn't bear it out. He talks about this, how Mr. Rosenbaum put this shirt over his head to hide his identity because he's going to go ambush Kyle Rittenhouse. Well, then obviously watch the videos. He's had that shirt on his head for some time. Whether it's COVID, this is all pre-vaccine as we know. Whether it's tear gas, whether it's fire, whatever it is, he's using it to protect his face, not as some evil plan to get Kyle Rittenhouse. They're setting this fire, and they begin walking down Sheridan. There's no evidence that they knew he was coming. There's no evidence that they had any plan to get him. I'd submit to you that the Zeminskis and Mr. Rosenbaum were doing what they were doing all night. They were going to go bash that Duramax or start or stoke a fire. Kyle sees this, and then he runs onto the scene. That's clear in the FBI video. He runs onto the scene. He puts down the fire extinguisher. He raises up his gun. Mr. Rosenbaum yells, "Gun, gun, gun." Why else would he yell that? It's very possible that while he was yelling, "Friendly, friendly, friendly," he's doing so while holding a loaded AR-15 at the Zeminskis. Mr. Rosenbaum was going to chase him out of there to end the danger. And Mr. Richards boasts that, something along the lines, "You won't do shit, motherfucker." Well, Mr. Rosenbaum is wrong. Oh, that's an attaboy right there. Way to kill someone unarmed because you won't engage them.
I agree. It is an attaboy.
He raises the gun. He provokes the attack. He has to retreat. He has to exhaust all remedies.
Like I said before, I agree with the outside the trial take that it needs to be a societal position that it's not just that Kyle didn't do anything wrong. Kyle did something actively correct. It is an attaboy when you defend yourself. It is an attaboy when you defend yourself. However, within the context of the trial, is that the best way to phrase it for the jury? I don't know. I don't think so. I hope it is. But like I said, there's two ways to go about that. I think within the context of the jury, it's not the tact I would have taken to phrase it in that way to the jury. But as a society, if we want what's happening to Kyle to stop, if we don't want that to happen again, as a society, we need to recultivate, yes, you get an attaboy when you defend yourself. You absolutely do.
Before he regains the right to even use self-defense, not even to use deadly force. That's a whole other separate question. He does regain the use of self-defense if he exhausts all options. He does not. He could have ran a different way. He could have fought. He had all sorts of different ways to exhaust his options. He did not do it.
Not true.
As I said in the beginning of my closing, I don't think you even need provocation. An unarmed man chasing you, and you shoot him 4 times as he's falling, you kill him as he's falling in front of you, because you don't want to physically defend yourself, that's first-degree reckless homicide right there. And Mr. Richards kind of plays games with the name.
That's crazy. Okay, so you've got that's the state's position now. Again, this is not just about Kyle now. This is about everybody in Wisconsin. This jury here is going to decide for all of Wisconsin whether or not you are ever allowed to defend yourself with a firearm at all. Essentially, his argument there makes self-defense with a firearm impossible, which that has never been the tradition of the law. That is completely new reading. That is a neoliberal reading of the law, that there is that self-defense does not exist if a firearm is involved. That's essentially what he just said there, that you have to be willing to get your face bashed in before you can start shooting. That cannot be. That is not the law. That is not how self-defense works. That is not how any theory of self-defense works. And there needs to be a national stand your ground law. I would say call it the Rittenhouse law, call it Kyle's law. There needs to be, the Republicans need to get their shit together and do something about this. There needs to be a national stand your ground law. There needs to be a national, I don't know what it's referred to in the car, but if you are in a car and a mob decides to stop you in your tracks, there needs to be a universal drive over your ground law. That needs to be done on a nationwide scale, because this is what the left wants. They want more victims. They want you to stand there and get your face bashed in. They want children to get their face bashed in by pedophiles, because that's the kind of person that this guy wants to protect, that Mr. Lunchbox wants to protect. Because, well, I don't know. You look at him. You look at this guy on screen right now, and you ask yourself, why is he defending the right of a pedophile to chase a child? Could he maybe have a conflict of interest? Because I think he does.
Reckless. Reckless means not intentional in this circumstance. And you can read the jury instructions, you can come to your own conclusions. And firing an AR-15 in any circumstance like this shows utter disregard for human life. There's no other explanation for it.
Firing an AR-15 in any circumstance shows utter disregard for human life. So as I said, their goal is to make a paradox where there is no ability to have self-defense with a gun. That it would essentially, well, as I said, make self-defense with a gun absolutely impossible, which is just, that cannot be allowed to happen.
If you're shooting an AR-15 at close range of people, you have no disregard for human life. That's not really in any
wow, he said it backwards, though. He said you have no disregard for human life, which
I want to leave you with
I would
this.
say that's true, but I don't think that's
the meaning
what
of
he meant
reasonable
to
doubt.
say.
I'm going to read portions of this instruction. Obviously, you'll have the whole instruction. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. That's what the defense is asking you to do, to guess what Mr. Rosenbaum was doing, to speculate what Mr. Rosenbaum was doing, to speculate and guess what Mr. Huber and this unidentified man were doing. We don't know because he killed 2 of them. All we can look at is the evidence and see him standing pretty much straight up, or exactly straight up, when he was shot in the hip and immobilized. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. The defense's whole case has been trying to stoke sympathy for Mr. Rittenhouse and showing how everyone else was just a terrible person. Every life counts. Every life matters.
I don't know.
If people did bad things
Rosenbaum's
that night,
life
they
didn't
could have
really
been
matter.
prosecuted. It's not up for Mr. Rittenhouse to be the judge, the jury, and eventually the executioner. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. There's a lot going on in this case. We all know that. We all knew that from the day we walked in on November 1st. But this verdict should be about what the facts are and what Mr. Rittenhouse did. That's what the 12 of you who go to deliberate will go and decide. You are the fact finders. You decide what is beyond reasonable doubt. You decide what he is guilty or not guilty of from this menu of options that you now have. An imminent threat. The only imminent threat that night was Mr. Rittenhouse. He was not acting
That
in
is
legal,
ridiculous.
justified self-defense.
They know that's ridiculous.
He's guilty. Thank you.
Thank you, Mr. Krause. Members of the jury, the time has now come when the great burden of reaching a just, fair, and conscientious decision in this case will be placed wholly with you jurors selected for this most important duty. You will not be swayed by...
Kyle's defense is not going to get a chance to re-rebut. That's crazy that the state gets the final say on that. All right, well, let's see what the judge has to say. From my scanning forward here, there's not too many more minutes left of this. The judge is going to explain to the jury, and then they'll head off to deliberate. Then God knows what happens after that.
Sympathy, passion, prejudice, or political beliefs. You will disregard any impression which you may have regarding what you believe to be my opinions on the guilt or innocence of the defendant. You will disregard the claims or opinions of any other person or news media or social networking site. You will pay no heed to the opinions of anyone, even the President of the United States or the President before him. The founders of our country gave you, and you alone, the power and the duty to decide this case based solely on the evidence presented in this court. You will fearlessly keep faith with those who have entrusted to you the fair rendition of justice and the protection of our freedom. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duties steadfastly in mind and as upright citizens to return just and true verdicts. You will decide only whether the defendant is guilty or not guilty of the offenses which are charged. Any consequences of your verdict are matters for me alone to decide and must not affect your deliberations. It will be for you to determine whether the defendant is guilty or not guilty as to each of the offenses charged or submitted. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other. This is a criminal and not a civil case, and therefore, before you can reach a verdict which may lawfully be received, it must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. That presiding juror's vote is not entitled to any greater weight than that of any other juror. We're going to stop at this point, and I'm going to ask that you return tomorrow. I'm going to let you take a vote. When you want to start tomorrow, you can choose 8, you can choose 8:30, you can choose 9. How many would be in favor of starting at 8:30? How many want to start at...
So they're in Central Time.
How many still want to start at 8?
So 8 a.m.
many would like to
Central would
start
be
at
9
That's the
a.m.
clear
Eastern.
consensus. Well, it's not a consensus, but clear plurality, probably a majority, I think. And so we'll start at 9 tomorrow, as we have been.
So that'll be 10 a.m. Eastern.
The case is ready for decision by a jury of 12. We don't have that. And it's just as important as ever. I'd say more so, except that it was always important, that you not discuss the case with anyone. And you won't have to resist that much longer now because you'll be able to decide the case. Please don't read, watch, or listen to any account of the trial or anything to do with the trial. And tomorrow morning we'll assemble, and as I indicated earlier, the tumbler over there will be used. All of your numbers will be placed in there. And 6 of the, well, assuming there are still 18 of you, 6 of them will be drawn out. And those persons will be held in reserve and will not join the 12 in deliberation. We're going to retain you here in the building. Those of you who are not selected will stay here in the building. And in the event that your services are needed as we continue the case. And then the 12 of you who are the jury selected will commence your deliberations at that. So, again, no talking about the case. Please don't read, watch, or listen to any account of the trial. Any questions, anybody? Enjoy the evening. We'll see you tomorrow.
All right. Well, you guys heard it from the judge there. The jury will start deliberating tomorrow at 9 Central, 10 a.m. Eastern. Hope I'm not getting that backwards. I'm pretty sure I'm not getting that backwards. deliberation, that could be televised, so we don't know what's going to happen in there. They could come back at 11 a.m. Eastern. They could go back a half hour after, 3 days after, 10 weeks from now. Who knows? There's a lot of evidence in this case, so certainly if they did review of all the evidence, they possibly could take a very long time.
I hope I did. If not, let me know.
Let's see what he's saying. Yeah, I don't think he's saying anything important there. I have to work tomorrow, so I am locked up until at least 5 p.m. Eastern tomorrow. It is very likely that when I get off work tomorrow at 5 p.m. that there will be a verdict. So that I will bring that to you. We might watch the actual verdict, depending on when it happens. From my understanding, Crowder has vowed to adjust his schedule tomorrow so that if the verdict comes out in the middle of the day, he'll be live streaming it then. I would recommend watching him if you want to catch it during the day. If it even happens tomorrow, we don't know if it'll happen tomorrow. I suspect it'll be a quick verdict. I don't know if it's going to be a good verdict. I am very concerned about some of the things that happened, some of the late argumentation. I'm very concerned about the blatant lying of the state prosecutors. I think that some of that could be compelling to a juror. I am concerned about the jury instructions and the way that the state has confused what the rules are for self-defense and the obligation of retreat. I'm concerned about that. I'm concerned about the additional lesser charges and the confusion of how those lesser charges interact with self-defense. I think that was remarkably unclear. And so I think that there's a lot of avenues for even a clever jury to find Kyle guilty on something, which is not great. I don't know. I'm very, very concerned about this. I do not feel good going into deliberation like I was hoping I would. Certainly as much time as I've spent watching this, I think I would know. Maybe I'm just catastrophizing it because it's such an important thing to happen. So I don't know. Like I said, I suspect it will be a quick verdict. I don't think it'll be as quick as like a half hour, but I certainly think that by 5 p.m. Eastern tomorrow that there will definitely be a verdict. Very sure about that. Could be wrong. And I suspect that the verdict will be disappointing. I am certainly open to being the opposite of disappointed, whatever that word is. But right now, I'm not feeling any better than 50-50. I'd say I'm feeling even like that Kyle gets off of everything. I'm feeling that he gets hung up on something. And my initial prediction way back at the start of this was that Kyle was going to get hung up on the first-degree reckless endangerment of Richie McGinnis, and I think that's going to be the one that sticks. One of the ones that sticks, certainly. And I don't know. I have some of my concern is this, maybe right or wrong. I've built this image of the jury in my head as a bunch of dullard idiots. I've discussed that before now. I don't really have any evidence to back that up other than just what I've already explained about jury selection, the way that process works, way back on the first episode where we reviewed the jury selection process for this case. So I don't know. That's, I'm concerned. I'm very concerned. We'll find out tomorrow, I guess. So, I'll be back tomorrow. Well, if there is no verdict at 5 tomorrow, I'm definitely not going to be streaming because God, I've been streaming so goddamn much the last 2 weeks. If there is a verdict by 5 p.m. Eastern tomorrow, expect me sometime between 5 and 6. If you would like to keep track of anything happening more real time than that, I suggest Crowder, who has vowed to live stream if possible. And I thank you guys for joining me on this wild ride. It has certainly been a wild ride, as I just said. A lot of work. watching all of the case and then streaming as long as I have every night here. So I thank you guys for joining me on that. Hope you guys have appreciated the coverage. And say a prayer for Kyle tonight. That's all I got. That's all I got. I will possibly see you guys tomorrow, hopefully. Yeah, Travis signing off. See you guys. Oh God, what's going on? What happened? Oh God, something happened and I can't get to the off button now. How does this?